You give all the memo.
And I might because that yesterday I was going to item number 70. So
Order has been passed.
My lord, I have already filed several types of memo. My lord, I have filed several types of exchange of covered matter, my lord.
What covered? Give.
Covered matter.
There is no covered matter. You don't know me. I may take a dissenting view. I can take a dissenting view. So what covered matter? Anyhow, give. Okay. I have a right to pull a leg.
Regularization matter of substance employee retail after 30 years.
Please.
They are put to retrenchment. They will be substituted retrenchment.
Please. Let's see retrenchment. What urgency? Let us see.
30 years they have worked.
Oh, so what, sir? So what? You are paid the full annullments.
item 30 of item 30. Item 30. On behalf of Mr. Lekha, life is suffering from illness with the honorable no.
Other side.
Other state law.
30.
No, it will not. 4 chapter also.
4 weeks. First time.
I think 5 is not important. Difficult to the academy next week. I decided to stay.
Wait, give it.
No issue.
Yes.
For delivery of orders, item number 1, WA 569 of 2025 and WA 643 of 2025.
With the direction and direction, writ appeal number 569 of 2025 is dismissed, and writ appeal 643 of 2025 stands disposed of. Interlocutory applications are disposed of, no cause.
Item number 2,
Yes, I think the Advocate General on the other day have said that within 2 days or 3 days I will take care and will do everything. What has happened? London Advocate General was appearing. He was there.
Nothing has been done.
He says that I will exercise my office and will see that everything is done within 2 days.
Current Advocate General already had a discussion with the officers, sir. And I will inform the Honorable for tracking the progress for today. Out of station. But from discussing his office.
Now, you don't have any information regarding any steps taken?
And now I do not have the information, but I will.
Are you appearing in the matter?
No.
How do you know that he had a discussion?
But actually, when the discussion was going on, by chance, I was present there.
31st, he will be here.
Oh, he will be here.
Also, 31st.
31st, my lord, I was inquiring, he is returning on 30th. He is returning on 30th.
31st, we are keeping it.
Item number 3,
In this matter, I pray matter be taken up on Friday. By that, we will open stock. This is relating to that construction of
Subcenter building adjacent to the present existing health wellness center at Alanda.
within 3 kilometer distance. But you may take up this matter on Friday.
Yes.
item number 4, Item 4.
Where is he? None appears in support of the requisition. Let this matter be listed after 2 weeks.
Item number 6.
Wait, please, Your Worship. There are challenged the rejection of the technical bid of the petitioner. It is at annex.
On what ground?
Ground that disqualified by the technical evaluation committee as per the DTCL clause 113G.
Okay.
113G is
What it says?
it is at page.
Actually, when at last occasion, clerkship directed us to open instruction below.
Correct. That is what.
Again, this matter may be taken up on Monday, we haven't got affidavit figure.
What affidavit? Instructions give us
But today.
when you are going to finalize the tender.
No, they're not going to plan. But for this matter, Monday,
It is submitted by the learned additional government advocate that the matter may be placed on next Monday. What is this date?
Fourth one.
Or to enable him to take appropriate instructions in the matter. So it is also communicated to us that the tender is not going to be finalized. By 6. Okay, 6.
This matter was sitting over all the letters.
Okay.
Sales.
Yes.
Seven minutes,
Yes.
also,
What for?
madam, this matter,
senior counsel, Mr. Devuta Satyapati is engaged in this case.
madam, actually, this matter is identical to another case, but if counter affidavit is filed in that case, arising out of the same tender mirror. They are in this case, they are challenging work order of opposite party number 4. In that case also, work order of opposite party number 4.
Oh, aquarium museum.
Acquiring. Counter affidavit is filed.
Oh, that experience certificate.
Experience certificate.
It can be tagged to this can be tagged.
And this is the number. WPC number 16916 of 2023.
Okay.
It is pointed out by the council appearing for the state that another writ petition being WP number such and such.
Item number 8.
Is hearing online in this matter.
Convince your sister.
Well, that's
You convince your sister.
like the minutes, probably 9 minutes.
Online.
Online.
Who is appearing?
Then it easy minutes.
My lord, on
Against whom we are fighting, my lord.
Against whom you are fighting, miss?
That's one bidder, my lord. That's these tender
I
conditions.
thought you are talking to us.
Yes,
That
ma'am.
against whom you are fighting.
My lord, that's that one bidder. Sorry, my lord.
Uh-huh.
Sorry, my lord, I am wrong. That the bidder who is usually everything has.
So against whom you are fighting? Tell us. Let us be a clarity in this regard.
That against one bidder
Okay.
who has all the tender conditions been tailor-made for him and they have admitted in the counter. So
Tailor-made.
admitted.
For him, it is all the things which
This
is.
have been done. And usually he represented by the current age. That's
He is represented by.
President Advocate General. He is the client of President Advocate General.
So what?
So I am saying. my
That is
lord.
a privilege of a lawyer.
Yes, my lord, that's always.
You have lot of clients.
Yes, and my lord, because that is why, my lord, this tender document, my lord, that's your lordship kindly see the counter affidavit for a moment. They have given me, served me to the late evening, my.
Who is appearing? Is not appearing.
I was told he's logged in, my lords.
Anybody logged in?
No, man.
Mr. Saswat Das is there.
But it's learning.
Learned AC.
Yes,
That is in the office.
and it's in my people possible too.
He's a very formidable opponent. You convince her.
No, my lord, just let it be day after tomorrow, I will find a short law. They
Yes, day after tomorrow.
have admitted everything in the counter, that's why.
Item number 9. Right. Item number 10.
Reply lordship super better. Butcher land is concerned. And butcher lordship that will be auction notice by the temple administration. Program seek to. Comfortable to do. Let's. In this matter. I will draw your attention to some of the provisions of the Act as well as Odisha Land Reforms Manual members. Yes, members.
There is a special act. I think the Jagannath Temple Act.
Yes, members.
And there is a land reforms manual which will prevail. Is a special act which will have a overriding effect on a manual, or it is a manual which has a overriding effect on the substantive law,
Yes, members.
a special law
Oiler is also an act. There is a Land Reforms Act.
is talking about manual.
No.
She talks about manual.
I'm talking Jagannath Temple Act manual is a special act which contains all the provision manual. And Odisha Land Reform Act was pointed out by last time.
Manual or act?
Odisha Land Reforms
It is a compilation.
Act manual 1960.
Act.
Act.
Now, look, when there is a special act and there is a general act, both are state act. Which will prevail?
My lord, first submission would be, my lord, Odisha Land Reforms Act, Section 8A is not applicable in the present case, my lord.
I'm talking about if there is
Special
a
act.
prohibition under the special act.
A special act.
International
Special act will be.
Jagannath Temple.
Well, this has been settled under the Supreme Court, my lord. So it's Jagannath Temple versus the Siddhamart case, my lord. It's in the Chavan.
Yes, what is settled?
The special act will prevail over
Or
the general.
these are two basic first principles of law. So that's why I'm asking.
My sir.
The first principle of law.
Yes, ma'am.
Yes, show us, Madam Jagannath Temple Act.
Jagannath Temple Act manual section.
They have floated a tender to grant the mining lease in respect of a Gochar land, which is recorded in the name of a Lord Jagannath. That is what your case is. Yes, madam.
The section 5 of the Act manual
Of,
of Jagannath Temple Act, 1955.
yes,
Section side number. If I may read this Act manual section.
please.
Notwithstanding anything in any other law for the time being in force in question or custom,
Correct.
usage or contract, sanat, deed or engagement, the administration and the governance of the temple and its endowments shall vest in the committee called Sri Jagannath Temple Managing Committee, constituted as such by the state government, and it shall have the rights and privileges in respect thereof as provided in section 33. It shall be a body corporate having perpetual succession, common seal and millage. Then if I may refer to my lord, section 33 of this act, my lord. Section 33. Committee to be in possession of the temple and its property. The committee shall be entitled to take and be in possession of all immovable and movable and immovable properties, including the Rasma Bhandar, fund, jewelry, records, documents, and other documents, my lords. My lords, if we read section 5 and section 3 in a cumulative way, so administration and management of all immovable property and movable property will be the sole authority will be the committee, my lords. So here, my lords, the land is recorded in Sri Jagannath Mahaprabhu, my lords, as a freehold property. He is the absolute owner of that property, my lords. And my lords, if I may refer to Orissa Land Reforms Act, my lords, section 3, my lords.
Yes.
What's the Land Reforms Act 1960, section 8A, my lords. Well, let's, if I may be permitted to read this section, my lords.
Yes.
Conversion of agricultural land for purposes other than agriculture, notwithstanding anything contained in section 8, the authorized officer may, where an application is made by him by a rayat, my lords. My lords, rayat is defined under section 2, subclause 26.
Means
Which means a person who is deemed to be a rayat or as such under the provisions of the act. And section 4, my lords, defines what is the rayat, my lords.
is what it says.
The following, section 4, my lords. The following person shall be deemed to be rayat for the purposes of this act in respect of the lands held by them, namely, person holding lands immediately before the commencement of
It is not a case.
Yes, my lord. Second, rayat in the district of Angul. This is also not the case, my lord. Third is rayat or in a rayatari village of Sambhalpur, not the case, my lords. All these are not covered, my lords.
Yes.
So section 8A specifically mentions if the land is held by a rayat, my lords. That means a tenancy holder or a leaseholder, my lords. In the present case, Lord Jagannath is the name of the Lord Jagannath Mahaprabhu, and he's an absolute owner of the land. So, my lord, this act is also not applicable in the present case, my lords. And the lands of Lord Jagannath will be covered by this special act, my lord. Which,
So what it emerges from this submission?
my lords, first,
That can the government go for a mining auction?
yes, my lords, because here, my lords,
Because the whole argument which you have advanced is unique. Says admittedly the property stands in the name of a Lord Jagannath Mahaprabhu. You have said that all the properties shall be in possession of a committee to be constituted under section 5 of the Act.
yes, my lord.
Section 33 empowers the committee to take over the possessions.
Yes, my lord.
So what it emerges is that it is admittedly a property recorded in the name of Lord Jagannath Mahaprabhu. The possession remained with the committee. And there is no other power which is given for the committee to do a particular act.
And it's, with that, we'll read section 16, my lords.
Now you say that 8A, which permits the conversion
Yes, my lords.
of a land from agriculture to gochar. Now, there are two aspects, whether the gochar land is an agricultural land
Yes, my lords.
or a gochar land has a unique feature
Yes. And it's,
where cultivation is not done and it is the grass which grows naturally
Yes.
for an intended or for the purpose of grazing by the cows or the cattle, let us be,
yes,
not cows, but the cattle.
yes, my lord.
Though the go word is used,
Animal.
connotes cow,
But-
but
Cattle.
animals, cattle, which there. So in that event, how a mining activities can
my lords,
committee is defined under
Section 5 is a constitution of the.
Section 4, clause A means Sri Jagannath Temple Management Committee constituted under this act. Committee.
Correct. Section
Then,
5 is a perpetual seal.
then this ROR, this
T or something.
150.
along with
The number 160.
Sri Jagannath Mahaprabhu Vijay Puri Taraf Taraf Marfat
Marpatar or the.
Well, if I may make advancement solution in the sense, under the 1955 Act, what is required is a sanction by the government, my lords.
What?
Section 16(2), my lords.
Yes, was.
How the alienation of the temple property to be done is covered under section 16, my lords.
Yes.
Section 16(2). Save as otherwise expressly provided in this act, no immovable property taken possession of by the committee shall be leased out for more than 5 years or mortgaged, sold or otherwise alienated, except with the previous sanction of the state government. Well, last time I had submitted those documents and I have filed an affidavit in the other matter containing all these documents. Here, the governor of Odisha, the governor has already accorded approval or sanction under this section for transfer of properties for mining purposes from the Jagannath, Lord Jagannath to the mining officers. The mining officer will conduct the auction. However, the proceeds will be deposited in the administration, my lords. That is in the modalities, my lords. If I may hand over this document, last time I had handed over, my lords. And accordingly, an NOC was also granted with the administration with respect to this, my lords. So, my lords, all permissions under this Act, 1955 Act, has been accorded. And accordingly, this auction was carried forward, my lords. And the question of conversion does not arise in the present case, my lords. And furthermore, my lords, this particular place is a hill, my lords.
Or?
This particular place is a hill, my lords. Where the auction, my lords, is taking, is going, release is
As the mining activities
yes,
is
ma'am,
going.
is a hill, my lords. And from last 30 years, mining activities has been going on. Before it was done by the committee, my lords. Now it has been done. Conducted by
Now
the,
we have to synchronize these two acts.
yes, ma'am.
Jagannath Temple Act, see, Jagannath Temple Act is a special act, there is no doubt about it. If there is any inconsistency between a special act and the general act, then it is a general act, it is a special act which will be. If there is something which is not provided in the special act, but an embargo is created in the general act, does it mean that those provisions would be inapplicable in this regard?
Well, it's, so respectfully, my lords.
Why I am asking this question? You have placed us section 5. We have also seen section 4 defining the committee.
Yes, ma'am.
We have seen section 33, which does not talk about anything except taking possession of the property of Lord Jagannath Mahaprabhu by the committee.
Yes.
Section 16, when you are referring, the subsection 1 creates a complete embargo that the property belonging to Lord Jagannath Mahaprabhu cannot be dealt with.
Unless there is a specific sanction.
Now, 2 says that yes, it can be leased out for more than 5 years, sold or otherwise, after obtaining a previous permission of the government or approval of the government. So what does it mean? That yes, the property as it stands, they can be leased out for more than 5 years, or may be sold out, or otherwise upon obtaining a previous approval. Does it mean that the moment and previous approval of the government is granted, the nature of the very land gets converted? Under the Land Reforms Act, there is a prohibition that you cannot use the land other than the purpose for which it is so recorded, unless there is a proceeding initiative and a conversion is permitted. If the conversion is only permitted at the behest of a riot, then in that event, there cannot be any mode of conversion of the land, as the land would remain as is where is basis. How can you use the Gochar land for mining purposes? Let us see, even a sanction is granted. Sanction is only for the purpose of leasing out the land as it stands, selling out the land as it stands. But it does not talk about the conversion of the purpose of the land.
My lords, respectfully, my lords, two acts deal with conversion. My lords, OGLS Act, which talks about deregulation
Sure.
and section.
Because this special act is silent so far as the conversion portion is concerned.
Then, my lords, if I may be permitted, then my lords, I will file a detailed counter in this matter, my lords.
It's a pure question of law, madam. I am not talking on a fact. I am simply putting a pure question of law.
My lords, with respect to the question which was put,
Section 8 capital A of the Land Reforms Act that talks about the power of the authority, competent authority to allow the conversion.
yes, my lords.
That is, the one nature of the land can be converted into another nature of the land. That means if it is an agricultural land, the conversion for a homestead can be granted. But if you say that section 8A has no application, then in absence of any provisions, can't you unilaterally convert the land?
My lords, with that respect, my lords, first, my lords, I will submit that both this act, Odisha Land Reforms Act and Odisha Government Land Settlement Manual, my lords, both the acts are not applicable in the present case, my lords. So there is.
Land settlement only applicable to government land. It
Yes,
is not a government land.
And my lords, Odisha Land Settlement Act, the application is only with respect to the Rayat land. Even my lords, the long title refers to tenancy or Rayat.
So if there is no law, then you, I'm asking a very
Yes,
simple
then-
question.
Then all.
You can sell, you can lease out
Yes, ma'am.
the Gochar land or whatever as it is.
Well, it's admittedly
But-
there is no other provision which talks about conversion, my lords. I checked, my lords.
So can you,
My lords, now if I might refer to section 5 of the 1955 Act, which talks about administration and governance, my lords.
madam, administration and governance means the protection is, the DT is always regarded as a perpetual minor,
Yes,
must be represented by some person, natural person.
yes, ma'am.
The DT is a juristic person
Yes, ma'am.
or a legal person. And therefore, any act which diminishes the interest of a DT, unless there is a conferment of power, you cannot do it. Or it is of a legal necessity.
Yes, ma'am.
There is no existence of a legal necessity. I believe that it is very solvent.
Here my only respectful submission would be, my lords, because this property is specially governed by this act because everything has to be done with, and this is a complete act. in
Can you
itself.
do it? And I asking you, madam, if that is the
There is
position,
no
how
other
can?
provision in any other law for conversion.
Then can you assume?
And
I'm asking you a power which is not provided under the statute. Can you usurp the power?
well, it's section 16, my lord, talks about sanction.
That is what I'm saying. Sanction for what? Sanction for what? Please
For lease.
read the section.
Yes,
For leasing out more than 5 years,
Yes, ma'am.
selling the property or otherwise.
Yes, ma'am.
Means that whatever be the nature of the property, that can be leased out, that can be sold. Does it ipso facto mean an automatic change of user?
You're selling the minor number of right.
But here in this situation, my lord, if there is no law applicable, in that case, a gochar land who has lost the character of a gochar can never be converted, my lords, then. Because from last 30 years, my lords, it has been used for mining purposes only.
Weird notion. The weird notion.
And my lords, if all the sanction and everything has been done under this act and proper,
Does it mean an automatic conversion, madam?
my lords, here, my lords,
A agricultural land is not cultivated for several years. Does it ipso facto make a conversion of that land? The purpose is still there. Whether you utilize the land for such purpose or not is not there, any prohibition. But you cannot utilize it for other purposes unless the conversion is done.
well, it's then I pose a question to myself, conversion under what law? If I want to.
There is the law, is a law, I'm asking, is a law which is applicable, and when the special act does not permit, then can you, I'm just asking, can you do it? But by using this particular executive fiat
Let's hear OGL is,
or transgressing on the legislative provisions.
and it's here conversion is only with respect to riot properties, my lords, as I have shown, my lords. So I'll pose a question to myself, my lords, if there is no provision for any conversion and the land has been actually been used for mining purposes for last 30 years. So even if
How it is used for mining purpose for 30 years?
because
How it is used?
before it was.
If it is illegally used, can you continue reaping the benefit from the illegality? Or at least the court must rise to an occasion, because after all, it is a Lord Jagannath Mahaprabhu's property. It's a duty of every citizen of the country, not only the state, to protect the interests. Oh. This cannot.
And it's I will be
This cannot be done.
this
cannot.
permitted to file a counter affidavit, my lords, in this matter.
No. How can it be done? This Land Reforms Act was enacted. It is really a legislation of an agrarian reforms. So one purpose has to be understood in this way. And if there is no provision which is there, that shows that the property of the Lord Jagannath Mahaprabhu has to be protected for all intent purposes. I do not know your interpretation of 8A is to what extent. Even if we do not accept your contention that the 8A does not apply, we think that 8A applies, yet you have to initiate a proceeding, or a proceeding has to be initiated for conversion.
Sorry, appeals for Jagannath temple. We may
Yes,
throw
what
like
you say, sir, you are appearing for
I am asking
the temple administration. What is this going on? You are the custodian, you are the custodian of the property. Can you allow this property to be dissipated in this fashion?
Since the last 50 years, my lords, this has been done because the major revenue of the Lord Jagannath, my lord. only the revenue which comes from the mines like 10 crores, 15 crores, 20 crores that utilized for the upkeep of the Jagannath miners for the expenditures of the budgetary. No other source, agriculture land doesn't give any revenue to Lord Jagannath. That's why the government has allowed with concurrence of the government and Temple Administrative Committee as per the act. This has been allowed this last 50 years, my lord.
That's
Not
how-
today, my lords.
How can you
And this petitioner's claim is, my lord, if he is allowed to mine, it's okay, no writ petition. If others are allowed by auctions, my lord, he has challenged the notice. It's very surprised. He said, my lord, I have been selected in 2018. This will be given to me. This Gautam land can be given to him, my
It
lord.
will be, he has flagged an issue. Now he's a whistleblower.
Man.
Maybe on a hindsight, there must be some wastage.
Man.
But the court once noticed that something is going contrary to the law.
Man.
Even if suo moto, we can initiate a proceeding and proceed for protection of the property.
Man.
There is no difficulty on our part. Forget whether what is his interest. We are concerned with the larger interest.
Yes, ma'am.
That what would we
They're the only usufructs of that immovable property, my lord,
tell me
have been sold
which
as immovable
provision,
property.
which provision
Reference from the government.
without a conversion,
Yes, ma'am.
which whether the property can be utilized.
Conversion is required for agriculture homestead only, my lord.
Sir, this is a
But-
gochar is what?
The
Gochar is a-
deregistration is required for mining activities, my lord.
this is recorded as a gochar land.
Yes, Gochar,
So,
the government,
What is the meaning of the word gochar?
Gochar is grazing land, my lord.
So,
Grazing land
Can you,
provided if
can
it
you,
is
can you
of
mine,
government, my lord.
can you do a mining activity?
Yes, ma'am. Here you can do it's our self-acquired property without interference of the government, my lord. Because my lord, why is
Very interesting. Suppose a person owns a particular big plot of land.
Yes.
And he found that beneath the plot of land, there is an accumulation of a petroleum product.
Yes.
Can he go on extracting the
No,
petroleum
my lord.
or the natural resources belongs to the government even if you are the owner?
Yes. You cannot
You
go
say
for-
absolute owner,
Huh.
I can do it anything, I can do a mining activity
Government will
because
do the mining activities with compensations to the tenants, my lords. But here in the case, this property has been, my lords, given for the survival of our temple, Lord Jagannath, my lords. As it's a self.
give me all,
Give all the
give
case
me-
law, my lords.
give me all your audited balance sheet to this court. Let us see that this is the only source
It's not the only
Of-
major source. I use the word as a major source.
of income of the temple for its sustenance.
Ma'am,
Let us see to go to that extent.
Ma'am.
And what are the surpluses which remained after expenditure? Does it cross the amount which you received as a royalty from the government? Your surpluses
Yeah.
or
Lordship will appreciate.
Give me
every
audited
year
balance
budget
sheet.
deficit, my lord.
give me an audited balance sheet. I'm directing you to submit in the form of an affidavit. Audited balance sheet that what are the incomes, what are the source of the income, and what are the expenditures
Ma'am.
which you have done.
Man, that will do, man, sir.
Do it.
Man, to correct myself, I have said the major source of income, and every year there is a deficit, my lords. That's a government, my lords, refill the deficit.
Give us that,
Yes.
the audited
If
balance
it's
sheet,
required,
there
we
is a
will give it.
deficit. There is a deficit. Let us see. Let us see, there is a deficit.
We will file a detailed count. So if you lost the permit, issue notice, we will file a count. In annexing all lordships require.
Also by the government.
There is a budget prepared every year, man. That will be.
If it is a budgetary allocations, then why?
I couldn't.
A institution
Yes.
is given a grant, and the grant is allotted in a budget.
Yes.
That the budget takes care of the expenditures to that particular institution.
We'll check it, man. So that- that-
And
yeah.
then
Every year government
you
gives
want
funds.
for the independent resources. If you are in deficit, increase the budgetary allocations, the government will grant.
In the act itself, it's there, miles. If there is a deficit, government will means.
What is the deficit? It's a budgetary allocation.
Yes, ma'am, there is a budget.
At the
All the
beginning of,
stats are there.
at the beginning of the financial year, they know that this would be an anticipated expenditure. And then the government grants you that particular money. If that is the position, then what more? Why you need more money?
Government
To
took the
take the
deficit.
interest of the.
Government refill the deficit matter. We'll give the details, man. So let us come with the counters, giving
Only deficit.
minus. It's my, there's lots of expenditure. My lords, Chhattis, Mrigos, Prasads, Rath Jatra, everything is there that we will give my lord details. That's it. Lord, that government last year also minus 500 crores they have given as a my lords corpus fund, my lords, because that
Not a
is
deficit, sir.
from the interest they survive.
It's
My
not
lords.
a deficit, sir. That is what I'm saying. Allocation, budgetary
That will check.
allocation. Not only.
That is
for
there,
deficit,
but I'll
sir,
place- we'll
budgetary
place, my lord, sir.
allocation means to run the entire thing. That's an obligation of the sovereign government to take care of that. And if they provide you, then what more?
There is no all mod systems are gone, my lord. Previously, what is happening, my lords, all mods are there. Mods generally they my lords, take care of the properties of Lord Jagannath. Usufructs comes and that are used for the my lords, this prasad and bhog and for the deity and for the Sevats remuneration and all. But that has been stopped, my lords, after this 19 judgment, my lords. But no mods are cultivating the land, neither they are giving anything. I will give all details, my lords.
No, but it does not wipe out the main issue of law.
Yes, we are there.
The main issue of law is different.
We will satisfy to that. But the last 50 years it has been going. 80% of these three queries, my lords, has been mined, my lords, with the concurrence of the government. As per 16.1 minus movable properties, we are studying the stone. Not only this granite minus the building materials, but we are studying like Khondalites. Yes, there are OMC is doing. Like there are this laterite stones. That it's also there. That is also going on with the due approvals of the government. Because of that earnings, that usufruct minus the temples minus day-to-day affairs are being looked at.
Why don't you undertake, you are an administration, this cultivation activity, there is a vast chunk of land belonging to Lord Jagannath Mahaprabhu. You are the administrator, you should take care of the
We
interest.
have been taking
And you are not taking care of an interest, then
80% minors are encroached.
you say, then why there is.
We have been fighting with the department minors to restore the possessions minors. That is going on. That's part of our minors process efforts minors to bring back all those properties. There are minors also be surprised that 1,80,000 acres of land that is not visible right now, man. So, but government is not
visible, the land cannot evaporate it.
Let's see, all are encroached minors.
Cannot evaporate.
Let's see, Kotak. Let's see, very much our all lands and encroached minors. In and around this High Court, there are Jagannath temples, land mass encroached. Nothing is coming out. In Puri, like this, Sargodar might have hide the name of Sargodar minors. There are thousands of hotels minors who have encroached. But we have been fighting minors.
Including your office.
Not my office, minor. I'm on a rent, my lord. Rent from the, that from the freehold tenant. Freehold tenant.
Of
No, there are lots of cases.
Lord
Here are my
Jagannath Mahaprabhu's land.
No, that's not. My office.
No, your office used to be next to it.
What has happened? Where it is?
It's just across the road.
You start with, yes, first.
Mine is not the temple factor.
Start
If
with
I find my
this,
sister, whisper
the
of
first
temple,
one.
I'll immediately leave my
And
house.
then we'll take care of others. That's true. You show your allegiance to.
Definitely.
Show your allegiance to. No difficulty. First, you start with that. Removal of the encroachment. Here, in and around the High Court.
The Lordship might have had the name of the Sorgodwar miners. There are hundreds of hotels miners that belong to temple lands miners. There are cases pending before the Honorable High Court. We have been fighting for eviction miners. Nothing is coming, my lord. They're all seashore lands, miners.
What you are talking about, do you know the flip side of this argument? Does it not show that the administration is completely incompetent?
No, we are doing manage. Litigations are going
First
on.
thing is, nobody took the stage when the first time the encroachment was made. You would have arrested the encroachment on the very first inception. Once they have built a castle, then you started saying all these things.
District administration is
And
cooperating minors.
we do not know what has happened.
Despite the warrant of arrest, everything is minors. They are coming to this court and getting stay.
What are you doing?
No, we are
Are you not in a
we are
position
still
to
fighting. We are
Are
still
you not in a
minors.
position to convince?
No, that we are doing minors.
What are they?
One by one, it's going on minors. Day by day, it's good. I mean,
But this is not the way you can do it.
no, I
Years.
Look at it, your conduct,
Which one, minor?
the suit which was filed way back in the year, you did not appear, ex parte decree was passed. After 25 years, you woke from a slumber. You just came from the slumber and then filed an application which was palpably barred. See your conduct. How I think very prompt you are. What is an alacrity shown by you in protecting the interest of Lord Jagannath Mahaprabhu?
Minors sometimes fence eats the crops, minors. A lots are there to protect. Fences eats the
crop.
Fence, minors. So what happens is that's why we are there to both my lord and we protect Lord DT minors.
This is not.
And that's all we are doing also. All fraud and forgery cases we are also.
These are the conduct which shows that you are not taking a proper care which you are supposed to take.
We will take.
What you will take?
it.
You are not taking. It is your solemn duty under the statute to protect. Are you protecting in this function?
We are minors trying our best to protect new management, new years. I have already taken initiated all the actions minors. We have recovered few properties which were already encroached and illegally sold. That we are doing that. Part of the management's effort, my lord.
Billing much bill.
I'll certainly communicate the message, my lord. I'll certainly communicate. Sir, I am part of your lordship.
I don't know whether you have
Yes.
proceeded.
Maybe this man will doing.
No, as a court of equity and a justice and a law. we will not permit. We owe responsibility to protect the Lord Jagannath's Mahaprabhu's the assets. We will not allow it to go wasted or to be used for some other purpose. No. No, yes, we can't. There are judgments, we have seen that one court may protect. Yes, we stop. So we will definitely, we will not. We will not. No. The way he argues that it will open a big Pandora box. And if the Pandora box is open, we don't know which way it will go.
It is here in this case,
I am
government
again
of
saying, the way you have argued, if we invite you to file an affidavit, we do not know whether it will open a Pandora box.
We'll assist your lordship, so we'll file all the documents, man, so we have. So far as this mining activities are going on with compliance with the government
We do not want.
approval mining.
We want something more. We will not stop at this stage, we will go ahead. We'll go ahead. It's up to you.
So we need to protect the interest of the Lord.
Definitely.
Definitely.
That is
We are with the
first-
lordships, madam.
That is the first and foremost duty
Yes, ma'am.
which we think
Yes, ma'am.
that we must protect the properties and the assets of non-government. How this property is being dealt with, I am really surprised.
Today, madam, last 50 years, this mining activities is going on, madam. And with the concurrence of the government are going. It's not that today, first time it's happened. This man has already taken in 2018 miners.
After the.
Luckily, my lord's
after
judgment,
After the completion of the mining activities, if the natural resources vanish or be totally utilized, what would be left for Lord Jagannath Mahaprabhu?
the other side of the one story, man, I was dealing with the NGT case, man, that's also pending here, my lords. Hundreds of acres of these minerals miners have been stolen without any revenue to the government, my lord. Sorry, this temple miners. And we have been,
Sir,
and that is also pending here, my lord.
the difficulty that also shows, may I use the very bad term? It also shows the incompetence on the part of the administration to administer the temple affair. Why not they should be removed?
The temple administration, government, everybody is, my lords, cooperating and trying to protect. Still,
You are really.
now the
Again,
advanced
backward
technology
that
has
come.
come, we have taken
Backward
the
that come.
help of the
And you are
technology,
really
my lords, that is.
showing a fast and loose at the same time.
No. Nowadays, man, these are the old case I'm telling, one instance is pending, but nowadays we have taken the all benefit of this latest science and technology, my lord. We have installed all drone activities, camera and everything, smell. That's now under check and balance, man. But the fact remains, man, this is the main source of income of the deities. That's why the government is permitting.
This is a budgetary allocation, what are you talking about? Whether it's that. Yes,
I'll check it, madam.
It's a budgetary allocation, you do not know.
No,
Then in that event, if the government is really supporting the day-to-day activities or the Seva Puja of Lord Jagannath Mahaprabhu, then what more resources you want?
I'm told that it is city matters that I'll confirm my and certainly assist your lordship.
Super cut. Yes, budget allocation there. They are lordship. Every year lordship. Yes.
But that seat is always filled by the government. That is.
No, sir, again you are saying something. Deficit is being taken care of, the government is one thing. and a budgetary allocation for meeting the expenditure for the whole year is a different thing.
That is there.
So
Budgetary.
why you say deficit means what? That does, if the chapel has its own source of income, administrator, and they meet the expenditures. Whatever becomes a shortfall, then the government comes and then rescued by paying those. That is what it is, not for budgetary allocation. It is what is a duty, solemn duty of the government to protect it. Does not require any budget for that. But once in a budget, a separate amount under the separate head is given, that this would be the anticipated expenditure, depending upon the total expenditures of the last year, then it does not mean that the independence income is already ingrained. No, never. It's an additional out of that budgetary allocation.
I'll check and examine it. Summary for you. So the budget allocation.
Is a budgetary allocation, I believe.
Yes, Lordship.
Every year, while presenting the budget by the finance minister in the assembly, they declare this amount. It has to be.
No, that is there, my
Provision,
but still, my lord's requirement is there.
the government was to be.
That there. That is
How the budget is prepared.
that provision that is there.
How the budget is prepared. The budget is prepared on the basis of the
That's it,
actual expenditures of the last
Income and expenditure.
of the last financial year. And because of the inflation having been made, some addition is there in anticipation that it will increase. This is how the budget is done. Shortfall, deficit. What do you mean by deficit?
This year, Lordship, 413 crores budgetary allocation and another 500 crores surplus fund. And Lordship, now there was surplus budget of 103 crores of temple administration this year.
Budget is there. Finance and budgeting. No, I am not with that, but always.
Chapter 4,
Yes.
22, Chapter 4, budgets, homes and audits. So they don't have to that. So
Yes, my budget and account checking audits.
before sanctioning the budget, the state government should satisfy the side. Adequate solution has to bring the budget for vigilance of the working balance.
Yes.
And for meeting all the liabilities of the temple and its investments. If the budget as submitted to the government
Yes, to make.
fails to make the provisions, instead of modify any part of the budget, she has to ensure that such provisions are made. The decision of the state government sanctioning the budget subject to the modification shall be communicated to the committee at least 20 days or when revised and supplementary budget section 26, then audit.
Everything is given.
Yes, 25, 26.
What are you taking? Then why you need an independent source of income? It's an addition to it. You have to just spend, you have to just add to an asset, not spend.
That is also a partment.
Different chapter. This is general.
There are more than 20,000 acres of Lordship agricultural land of temple administration. If they will cultivate Lordship, crores of rupees come for every year. Instead of doing so, that every year they are going to settle the land in favor of the encroachers Lordship. Because this attempt is very easy Lordship to sell out the entire property. And last year Lordship, from Cuttack we have handed over 40 acres of land. By interview this honorable court, we have identified 40 acres of land and we have handed over to the temple administration. And by interview this honorable court Lordship.
Talking, madam. Section 15, capital B, which was introduced subsequently, that permits the change of user. Of the Jagannath Temple Act. It was introduced in 2004. That permit, you can change. Yes. The proper. You can apply for a change of user. The power is given 15,000. Have you read it?
Minutes, I've underlined it also.
What?
I've read this provision, my lords.
So you say nothing is there.
I was under an impression, I read it in other ways.
What other way? Look at it very simple way. The chief administrator may either on his own nation or on an application made in this behalf by any seva. So suo power is also given. Other than the Raja of Puri, and after making an inquiry in a prescribed manner, make an order affecting any change in any entry made in the record of rights, or all or any of the following grounds. That is, that such change is necessary in view of the new material which has come to the notice, that any entry made therein bears no relation to the existing facts which he is saying, or that any such entry is incomplete or incorrect, provided that no order on this section will without giving a reasonable opportunity of hearing to be heard. So this power is given. Record of right is maintained by the land department. Correct. So in that event, it can be because you may come under the B or C, B, or A and B you can come. Because it is no longer used as a gochar land, so the purpose is there is a new material that has come which requires the conversion, and then entry bears no relation because there is no gochar land. So the entry does not bear the existing fact.
These are all vertical hills, madam. That's
Who is the administrator?
Administrator. The Sahu, Devabhrata Sahu.
We should call him to appear personally before us.
Devabhrata Sahu.
To call him to appear personally before. Yes. That you have taken reports to such a degree.
So I'll file the details counter. With the shooters.
Sir, you have chosen a wrong person.
And I have not noticed it, my lord, sir.
No,
I have just.
these are all the pure question of law.
My lord.
And this counter affidavit affair sometimes delays the disposal.
Whether the change, nature of the land has been changed or not.
Comes with the document, if we find.
I'll file with
it is
document.
There is nothing. Then we can simply say, put it on affidavit
Will
within 1 day.
you put it in affidavit, but
Not
I have
required.
not
First
read
was the document.
Madam?
I will file a counter, will not do. First come and say yes or no.
I'll take instruction. I'll ask the committee to provide the documents and today just my instruction is given to see.
Should I record whatever you have submitted?
No, but that is after my lordship asked me, I just appraise your lordships about the temple of yes, fine. But today we will confine to the retreat.
Or attention is drawn to There is a interim order in other matter.
No, sir, this matters. This matters.
Interim order granted earlier is extended till the next thing. Because we have already indicated that what is the issue, show us.
The may prefer on 69 to do, not inconvenient. Take the system.
What is the difficulty of four?
I mean,
That is.
only one day, if a third minute.
I have also have the same genes.
Alright, no problem. No problem.
Whenever the court suggests a date, lawyers have always a problem on that issue. They wanted to share this with us. The genes, so that is also embedded.
Mine is that's it.
Yeah. Are you in
My
difficulty
colleagues
or
are
four?
Malad?
Are you in difficulty or four?
Yes.
What if?
So, other hearing matter as posted to that.
Which date?
Oh, let's say, post to 5th minus or 6th, whatever.
Yes.
Fifth. What's the place?
Lordship, I apologize.
Item 11.
Please, petitioner before your lordship is MSME limit. And as per the MSME Act, he has suggested, he is also registered and he's got a Udyam registration according to the MSME Act. So these MSMEs are.
Yes. That MSME
Is the small.
to a hospital-based service.
Sorry?
Our MSME is applicable to a hospital-based service.
Here, Lord, it's a service which is being rendered. That's a hospitality service.
Maybe
Manage. And
for that MSME.
no, so my humble contention is this, so far as the petitioner is concerned, it's an MSME registered unit. And as an MSME registered unit, they enjoy certain facilities given by the central government as well as by the state government. One of the facilities, my lord, is an exemption of the earnest money deposit. So a tender was floated, by the Indira Gandhi Institute of Technology at Sarang in the district of Jagannath, which is a technical institution, an engineering college, for running of its hostel mess, for which this particular petitioner was an intending bidder. But my lord, it could not bid for the purpose that this particular earnest money deposit amounting to 3 lakhs amount was prohibitive so far as this MSME is concerned. Because
Prohibited, why?
Prohibitive, my lord.
Prohibitive.
My lord, and my lord, so far as these earnest money deposit is concerned, I'll take into your lordship's finance, the department's notification of the central government as well as the state government. It is as so far as MSMEs are concerned.
It's not.
It's
an exemption. So
right.
have you disclosed that you are an MSME?
No, I could not know because
So have you disclosed that you are MSME?
in the petition, yes, but I could not, my lord, submit my tender because one of the technical is a 2-bid system, my lords, and my technical bid will be rejected if I do not give this earnest money.
Why? If you show a certificate.
But they do not have the provision. With great respect, my lords, so far as the tender condition
is a in tender.
It's a by post. They give it by post. So no, if I my lord, your lordship would appreciate the tender conditions are such that it does not carve out any exception for MSMEs. If your lordship.
Then I understand that until if that when you are given an exemption under the special statute, they cannot defy that statute. You ought to have participated by sending it. And if they reject your bid on a technical that you did not affix that particular EMD, I can very well appreciate that we have a genuine grievance. Without participating, anticipating that your tender would be rejected at the technical bit. If it is an e-tender system may not accept, I can understand. But you say physical.
No, this is a physical one. But
So-
it has to be
So
sent.
you can dispatch it. There was no difficulty. You could have dispatched.
No, the last date is still there. 31st is the
You go, it's a premature, you apply. If they do it, then we'll come.
that observation.
No problem.
No, you're not able to see
can't, we
the foreign
can't proceed on that.
the foreign movement.
Let them, once you go, let them reject, we'll consider. We will not.
No, the lordship may only see that clause.
No, which clause?
The page at page 23, Lord.
Yes.
I'll not it's annexure 2, it begins at page 21, page 23, Lordship. There's no clause 10. There's no mention of a and your lordship got it from page 23. EMD of so and so. And my lords, in specific other tenders, my lord, of course, from my personal knowledge, a exception is carved out for registered MSME units.
So
Because as per
they
the
can't restrict it. They can't, they have to.
no, but they can't, Lord, but at least they could have put up a clause that if you are an MSME, you are not to abide by this particular clause. They have not done so. In
It's not, what if they have omitted? That does not mean that the law which is there in place, which says that the exemption from submitting the EMD is given to this MSME. How can they define?
No, they can't know. But unfortunately, in absence of such, look, my technical bid would be rejected on that ground itself. And your lordship would see
Let them take a decision.
and your lordship would see the schedule, bro, at annexure
No, but it
21.
is absolutely premature because you have not applied for this.
Your lordship, for a moment, I'll be just making humble effort, my lord. Page 21, if your lordship would see, last date of receipt of the tender papers is 31st of this month.
Yes.
Date of
This is
opening,
there.
date of opening is technical bid is 1st of, and below the time of opening of the final
You have
bid,
to say
financial
that
bid is,
you are an MSME and therefore in view of the law,
I'm
you are
prevented.
exempted from giving an EMD. They will take. Can they, then will they not offend Article 14? Once means what? It has to be, you can't.
The conditions will not has to stipulate that there is some Milord's waiver for
If
MSMEs.
the conditions have violated any of the fundamental right guaranteed under the constitution, does it mean
But your lordship could,
you can't come?
no, but your lordship could kindly see clause 14. If the conditions are such, the technical bid, what it should contain, my lords.
Yes, sir, I
Clause 14,
understand.
my lords. And at the last, my lord, they say,
It says EMD of 3,30,000 is to be given.
so my
I
lord,
understood.
this is an essential condition. For
True, but for that, that you are entitled to an exemption. Will you not?
my humble submission would be that they should have reflected
Exempted from it. It is one line you wanted from this one. No, anything. They wanted.
humble submission would be this much. That but for excluding these MSMEs, Lord, the conditions are onerous and bad. That is my prayer. Because, my Lord, this is preventing me and persons maybe similarly situated for participating in the tender itself. my Lord.
Server notice and come back. Short notice.
Well,
38 tomorrow, oh, not yet, today is 29. Come on, 31st.
So I take the dusty. The lordship would
Not dusty, you serve the copy of this, taking that this application. The advocate has recorded the petitioner is directed to serve the copy of
Item 22.
22, your lordship, is non-constitution of GST tribunal.
Lordship, I don't understand where from my learning friend additional standing counsel of my department has given that instruction. I'm sorry to say, I'm sorry for that instruction. That is a paper publication from where? That should not be the submission of.
I do not know this, so we were hopeful that it
I have-
will be constituted.
I have gone through in VC, your lordship, very sorry, state of affairs, I'm sorry, I'm so sorry.
Who submitted on the last one?
In fact, very shortly, I prayed for 4 weeks time. Very shortly.
It is very shortly, it is going to be done. That is what I wanted.
Till
It
date,
says that no steps have been taken till now.
till date, appointment has not been finalized, till date, your lordship, many things have to be done, your lordship. Then after notification will come, then 3 months filing, your lordship, many things have to be.
No, thereafter.
3 months from the date of notification filing.
I suppose that CBC circular is not amended yet.
Not,
That says that the review when chairperson takes
your lordship,
office.
your lordship. Your lordship, I
From
know,
there,
know what your lordship indicated.
Section 107.
3 months time.
Already.
Appointment has already been done. More than 1.5 years have gone.
Your lordship, that must be amended, your lordship, until unless that.
Wait, I'm not saying. I hope that it's not amended, that's what I'm.
Not amended, not amended.
So how, then the deadline has not been adhered to.
So it is already lapsed. So how many days we will keep this pending? That is what we were discussing. Why this adds to our pendency?
Only process is going on when we have.
Why carry this burden of the others?
Yeah.
Mr. Celia, you must be in a position to answer. Because
We are expecting that tribunal is going to be constituted in the end of October.
last year to last year.
Which year? October of 26 or 27?
25.
In this school last year,
Appointment will be done. Initial appointment will be done very soon. Will be
Is there infrastructure available?
already they have started infrastructure. But already they have signed the agreement with the person. The place of business has been already taken on rented basis. And that work has been also started. Huh? Cutter. It has already been started.
So at the rental premises.
At the rental premises. They are taking to 21,000 square feet of land and IPS in Qatar.
Constructed area? 21,000 square meter constructed area.
Mr. Sarpadi, you not any information. You are civil planning.
Government of India has to be, because Ministry of Finance is.
Must have information.
Only answer.
You have asked.
And when any instruction has been called for, it is in process, your lordship, only that much of instruction is with us.
Yes.
Item 23.
May be your lordship. A small prayer, my lord, that this present petitioner, I have committed the mistake. Present petitioner committed the mistake. Instead of depositing the GST amount on regular GST number, he has deposited that amount on TDS GST number. So this was the.
Your lordship, on the last occasion, we don't have.
There was one matter.
This matter, your lordship.
Yes.
This matter. Your lordship,
This
on the
matter. There was another matter, I think. This matter.
Another matter.
The same thing happened.
In a temporary registration number, you open and you have proceeded with an assessment.
No, this is
It
different.
also.
This is different, man. This is what happened. This is what happened. Let me clarify.
My lord, I have committed the mistake. Instead of depositing the amount, my lord, in regular GST number, I have
The same thing happened there also, that instead of depositing in a regular GST number, the TDS.
This matter, your lordship. So your lordship is sitting, was sitting with Honorable Justice Pathak, your lordship, the last occasion. Your lordship was directed to state GST as a party, your lordship. This matter. This matter.
And I have made there has the opposite.
All the money has gone in the same department.
Yes, ma'am, same department.
Only thing is under the different account.
Instead of my lord depositing in TDS GST, I have wrongly deposited in the regular GST number.
Here your lordship, here your.
It is a fact.
Listen,
Why do that?
your lordship, the petitioner is to rectify the mistake.
Not rectify. Now, how can he take back the money?
No, he cannot.
Then what he will do?
Your
How he
lordship,
will rectify.
your lordship, he should have rectified within the period of limitation.
What is the rectification I just wanted?
So that.
I have remitted the money
Your lordship.
in a particular department, in the same department.
Your lordship.
Now the department maintains, they say several accounts or different, under the different heads.
Your lordship.
Now the money has gone in one head. It should have gone in other head. How he will rectify? He cannot take a return of the money, can he? And then deposit in the correct one. What is the rectification you thought?
The rectification in the return, your lordship, whatever the return has been filed by putting it wrong GSTN number. So he has to rectify in place of wrong GSTN number, correct GSTN number. VNL is the recipient. I'm not, I'm to the GST. That is to be done by central GST. Your lordship, the petition is under the control of central GST. So here, since the date has been already lapsed, your lordship.
Then why the state GST is arguing?
In fact, we did not have the copy. Last occasion, your lordship was directed to implead us as a party. For that reason,
Good reason.
I'm saying for all the.
Only for that reason. Yes.
No, your lordship, actually, he has rightly submitted the representation. Please,
Within your domain.
I have
The registered person is in your domain.
I have to verify.
In this matter, GSTN has need to be a party here because GSTN is managing all this software. So it is a software problem because it cannot be.
It's not a software problem.
No, Lord, suppose he has paid certain amount, but software has been adjusted the amount in certain account.
Correct.
It should be transferred, only GSTN can do it. Even
That is what it says.
so he made a party GSTN.
You are representing GST?
Yes. So if your lordship
And the party
GSTN and give a copy to
So now, my lord, I am handing over the copy.
plus implead first.
input for GSTN.
Central GST leave is granted to the minister to implead central. Here and now. The copy whereof has been
Thank you,
served
Lord. So
upon,
pass and sort order so that I can.
all the copy whereof has been served upon Mr. Sarpati, who normally appears for.
Senior study. GSP and as well as TGS.
Yes.
Organization.
The concerned department is directed for recognize his appointment in the instant matter. Mr. Sarpati. Raised for.
Please stand.
Raised for 2 weeks' time to take the necessary instructions. Depositing the text. Welcome. Yes. Go ahead.
Item fixed for 2 p.m. Item number 39. 39.
Very shortly.
Well,
Are you there?
Item 39. Just where the validity and legality of exemption provision exempting a qualification prescribed under the section 23 of RTR, that is under challenge. Sir, I have already earlier. Yes, ma'am. RCFC Act. Right to Free and Compulsory Education Act 2009. But although earlier I had filed a compilation of Act rules.
This is.
Yes, ma'am. I am coming to, but I have kept in mind.
What is a highly contested matter
Right.
Why it has been mentioned to take up at 2 p.m.?
Because on that day, my lord was reached to.
I didn't know. I just, you said that admission of class 6 or something.
Your lordship, after referring to the Gaurav Kumar case, also caution us that within that 6 basic ingredients, your case is required to be made out. If at all it is
No, I have directed this.
And
39 to 33.
your lordship, that is why your lordship was pleased to fix this matter.
Now, will you argue or Advocate General will argue? No, sorry, Deputy Solicitor General or is a central act.
Yes, ma'am.
Yes.
You are challenging the virus.
Virus of the state rule is state rule, which is framed in
Then
person.
Advocate General will argue or you will argue? You will argue. Ready?
Section 9 petition has been.
I have just handed over the compilation of Central Act and rules framed by the state.
My lord, Harish, you also posed me that question whether you will argue or advocate. I was saying challenge it will be better. I have gone through
That's why, because the virus is what.
virus has been challenged. That is why
I firstly thought that it must be a parent act. Then I asked learned DSG to take care. Now when you say the rules, then the Advocate General has to be asked whether he will argue or you will argue.
So, right question.
Anybody, I have no difficulty.
since the virus has been challenged, it will be better if
Then I have to take time, my lord. This state is the implementing authority. If you want to argue about the virus, then I can give some time. I'm ready. And address the court.
You are not made party.
Yes, we are not mad party.
Subsequent case is party.
OP number 3, the HID ministry now is a matter of education department.
Yes, ma'am.
HID ministry is not there now. It is Ministry of Education.
You have filed any consolidated cost section or something like that?
Because HID ministry no more is a organization the stand in the government of India.
But in the meantime, what is happened, Lordship, may kindly 1 minute. In following the exemption provisions,
What is the exemption?
Exempting the requisite qualification which is required for recruitment as well as for promotion within the elementary cadres from one level to another level. That has been exempted in exercise of power proviso to Article 309, and that has been issued. Particularly when the rules framed by the state government in exercise of power, Section 38 of RCFC Act is governing the field, clearly stating that state is to make a request to the central government. It is the government to examine, thereafter exempt. It is the central government to examine.
Can you place the parent act?
Is for particular sect, not in entire.
Can you place a parent act? Can you place a parent act? What it provides?
That in compilation I have given you.
Where is the provision under the Parent Act?
Yes, madam. The right of children to free and compulsory education act 2009.
Correct. Show us this.
The definitions that I have stated likely to be relied that I have mentioned. Elementary education. First in my compilation. If you not,
I do not want to go compilation. Yes. Elementary education is defined in section 2.
Elementary it is 2F.
F. Education from 1st class to 8th class. Then
yes, madam.
8th class. Then
your lordship will find 2N.
School.
2N.
Recognized school imparting elementary education include the
established, owned, controlled,
appropriate government or local authority, aided school.
We are confined to that, not
A
subsequent.
school belonging to a specified category, unaided school not receiving. These are the 4 categories. Then
we are falling in first category.
First category means established, owned and controlled by appropriate government or local authority.
Yes, government.
Is a government. Then Yes.
My lord, before that, my lord, 2A is the appropriate government, means central government, so also the state government. That is 2A.
Yes.
Appropriate government means in relation to school established, owned, controlled by central government or the administrator of union territories having no legislature, the central government. In relation to a school other than the school referred to in subclause 1, established within the territory of a state by the state government or union territory having legislature, the government of that union territory.
So it's the government.
Then you lordship kindly turn to section 8, man. That in compilation I have also taken note of.
Yes.
Which is likely to be duties of the appropriate government.
Correct.
Appropriate government shall provide free and compulsory elementary education to every child, provided that where child so and so. Your lordship may kindly turn to explanation. Compulsory education means obligation of the appropriate government provide free elementary education to every child of the age of 6 to 14 years. And my lord, I am coming to ensure all these things. B and G provide infrastructure including school building, teaching staff, and learning equipment. G is the relevancy. Ensure good quality of elementary education conforming to the standards and norms specified in the schedule.
Correct.
My lord, schedule is the backside, my lord, attached. Before that, my lord, your lordship may kindly turn to section 23. Page 12, section 23, qualifications for appointment and terms and condition of service of teachers.
Yes.
But may I read one? Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Number 2 is relevant. Number. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications laid down under subsection 1 are not available in sufficient numbers, the central government, central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. It is the central government may.
That is as a stopgap measure for a period not exceeding 5 years that can be done. Central government. But after all, it is an obligation of the state to provide.
I will come to the rule also. Central rule, so the state rule. In the same parlance, they have what the criteria they have picked. Proviso is important. Provided that, this is very important. First proviso. Provided that a teacher who, at the convents.
Yes, if he does not have a qualification, he will acquire within 5 years.
But this was existing on the commencement of the act. The second proviso, but although we have relied, your lordship will find that the only time limitation that was extended, provided further that every teacher appointed or in position, like of teacher at the time of commencement of the act. That means the all existing teacher is to acquire the qualification. And every teacher appointed or in position as on 31st March 2015, who does not possess the minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children to Free and Compulsory Education Amendment Act 2017, which came into force, it has been inserted with effect from 1/4/2015. Well, that we have enclosed in our annexure as to our read fiction. In every read fiction, it is available. My lord may then kindly turn to section 38. which the general enabling provisions, my lord. Page 16. Power of appropriate.
As a rule-making power of the appropriate government.
But we realize the appropriate government may by notification make rules.
Oh, which clause?
My lord. I realize that is the L, my lord, your lordship. The salary and allowances payable to and the terms and conditions.
Anyhow, the terms and conditions and the salary and allowances.
Section 2 and 23.
Yes.
My lord. Then your lordship, that it said the 3 is also. Every rule is to be laid before the parliament, and like of the state government while exercising the power under 38 is to lead. That is 3 and 4. 3 deals with the central government, that is to be approved. Thereafter it will be effective, and 4 is also the same manner. If state government in exercise of rule, in exercise of power of 38 framed any rule, then it is required to be lead before the assembly. My lord, your lordship, what we left, my lord, the schedule as per the norms of the schedule, which earlier we read in the definition in the clause, section 8, that is 2 categories. One from class 1 to 5, but another is 1 6 to 8.
What?
My lord, one category that is in schedule.
Where?
Page
Where?
18. Page 18.
Yes, that's a pupil-teacher ratio.
No, my lord, here the qualification has been also, well, I will come to that.
Yes.
My lord. You will see 2 categories. 6 to 8 one category, then 6 to 5 is one category. But accordingly, your lordship will find annexure 1 to my repetition, central government notified in terms of section 23(1), the NCT is the prescribed authority. And after notification, NCT, who has been exclusively empowered to prescribe qualification, not to relax, he prescribed the qualification that is at annexure 2, my lord. Your lordship, in my spiral binding, that I have given even the circulars, they are relying, and we are relying all the subsequent development.
Where is the circular? The spiral binding.
Small spiral. The big one is judgment, another is yes. Hearing closed. Because the hearing was closed, reserved for judgment.
No.
And it was
Let them supply copies.
But copy, if they say has not been supplied, how they will come to know?
Yes.
And these are the part of your pleading. Have you annexed those
Yes,
circulars?
in reply, even in my all the documents are not in my writ applications. I have enclosed here the spiral binding.
Can you rely upon a new document which does not form part of the pleading?
But we have been made it. I will serve, my lord. I will rely.
Must you serve then?
You will serve because. And then I will serve. I will serve the next by tomorrow, my lord. I will serve. I will serve by tomorrow. If there
I can appreciate what I perceived since last many years, that there are very voluminous documents which are annexed to different applications which are filed by the parties. Those are on record. In order to just avoid anything, they have made a compilation that these documents are already there. I'm just making a compilation so that. But here it appears that these documents were not filed along with the pleadings.
The important documents are part of the record, which now I am going to rely. That is annexure 2. It is available here. That is also available in return.
But if you rely some more new documents which are not there, then they have a right to peruse. That's a valuable right. How can a person be taken to surprise? Something new.
But I have also enclosed document they rely during the course of hearing.
No, that I appreciate that those documents are already there on record. For the purpose of convenience, you have made a compilation. No difficulty.
May I propose one? I will supply the copy, then let it be written on both the 5th.
On the last occasion, why you did not?
He has not been.
He has not given.
It has concluded everything. I will apply, my lord. Like it's common, my lord, Thursday, my lord.
Since more than 30 years you have been.
Sir, you are a veteran in the profession. You should know that what is required. You are relying on a very new document. Maybe is a public document, but they have a right to look at it.
My lord, I will summarize. Your lordship.
We never come across in this way that it is done. One document's compilation without serving a copy, relying.
My lord, we will sort, my lord, by tomorrow. Your lordship may call this on Thursday.
We can't do it in this way.
We must have to give some.
What they have might have done, they have made certain relaxations, which according to him,
Currently, if you not
give him a copy.
I'll sort. One copy is there, since my lord, I have to sort the number of copies, I will sort.
Serve that. And you are appearing for the state, and you are appearing for interveners means the teachers who does not acquire a requisite qualification within the extended time. I understood the moment he opens the brief, I understood that what he actually aimed at. That is what is understood.
Well, dispute is only related to teacher eligibility test,
Oh.
not the requisite qualification. Everybody is in possession of the requisite qualification. So far as passing of PET is concerned, since it was introduced by the NCT, which is the prescribed authority, in 2000.
This has been hovering around throughout the country.
Yes.
The TET is there. NCRT is the authority who prescribes, and there are at least 4 judgments of the Supreme Court in this regards are there. We understood the way he started.
Yes. NCT regulation also makes it mandatory.
Sir,
Yes, we are also relying upon that.
I had an occasion to deal with hundreds of those cases.
My lord, in subaltern 3, I have already prepared my written notes, everything, man. So.
You are also challenging the virus.
Yes.
Yes. So at least we get the respite that we will not hear you because you have already filed your written. He will be the lead the counsel.
But our case, we have filed earlier, and he.
Oh, so.
Pleading, our case pleading is complete. Every counter, regional, everything is complete in our case.
But the catch in this case is 3-0 proviso will prevail, or the provisions of the rule even framed by the state government is to prevail. Rule has been framed in exercise of 38, section 38. That is the crux of the issue, man. And that is hit by the doctrine of occupied. There are many supporting principles.
No promotion has been made.
But let it come on Thursday. I will buy tomorrow, my lord. I will start.
Supply after 18th of August.
Because your lordship will find that the state government has challenged a single bench judgment which has been tagged with this. That judgment was passed basing upon that exemption provision, and that has been tagged with this. And state government challenged on the ground that it violates the RT Act and the rules. Therefore, the state government has the stand, contradictory stand. That is why your lordship earlier ballot was pleased to tag all those matters to be heard along with the WA matter. In the WA matter, they are the beneficiaries of that exemption provisions, which the single bench approved it. And my lord, your lordship, while pending, the matter was pending before this court. What did my lord, the single bench approved that in terms of that? Yes, my lord. The approved, my lord. And my lord. No.
With this word.
But following the exemption provision,
they were giving the clean sheet and they were giving the promotions. Even a teacher, your lordship kindly appreciate, we are all entered with the TT qualification. Even a person entered 31st February 2011. Yes, yes. Madam.
Wanted to clear all the obstacles.
Now, my lord, government has come forward, but another development has taken place. Government has come forward issuing a letter, instruction, that only TT candidate will be promoted and their cases is subject to the result. Now, that has been again challenged in the single bench. That is why it is a case of thousands of teachers' future. That's why we pray, your lordship, any day, my lord, your lordship, fix it. I will come serve all the copies by tomorrow.
Lord, except the writ petition, I have not received any.
My lord, I will serve an extra copy.
So let them serve all the.
Yes, my lord.
Respective councils may serve all the copies, then I can.
My lord, central government is with us.
Monday.
Blood.
There are many fresh matters in that.
Yes.
So then you will come on Tuesday.
Yes, ma'am. Man, one thing, my lord. We have made a party to NCT. Let the NCT file a affidavit in the same day. My lord, I am the petitioner of.
NCR.
No, NCT is a party, my lord.
Not a NCT.
No, my lord.
Espousing the cause of the NCT. They do not want to file article and why they have chosen not to file.
Yes.
So why you are complaining?
Already said.
So,
It is adjourned to which date?
That's why I discussed it.
Twenty-four, sir.
That question involved in this case.
Your clients are always having problem with the assessment order. Why?
The reason being that faceless assessment, lately central government, parliament made it mandatory. Section 150 was introduced to 151 capital A. But faceless assessment, and it's a mechanism developed by the legislature to make it transparent, to eliminate interference.
Yes.
So that is how it's mandatory. And Honorable Supreme Court very recently, it's an order dated 16 July 25, very recently in Puranjan race case. Because Honorable Supreme Court said that because all these independent race case, these are all mandatory and that cannot be specific at any cost. So therefore, our consequence assessment also go, notices the proceeding will also go. And this arises from out of the judgment of Madras High Court, Telangana High Court.
Why the Panchal lawyer's battle is taken?
The main case arises out of Venkatraman Reddy Potula, and that is accepted by
Where is the Dipanjan lawyer's judgment? High Court.
I'm giving Vilas. Dipanjan Roy was disposed of in terms of Venkatraman Reddy's case. And now that is confirmed by the other court. I am giving it your Lordship Telangana High Court judgment, detailed judgment in case of Venkatraman Reddy. So you may kindly see that.
Consent order, what? This is really virtually a consent order.
But so far as compliance to 151 is concerned, this is mandatory. That cannot be without any count.
This WP 13353 of 2021, this is not the same case.
That Venkatraman Reddy belongs, your Lordship kindly detailed judgment of Telangana High Court belongs.
This is the case.
Yes.
This is the case.
It's a detailed judgment. And Honorable Supreme Court, that was approved in the Puranjan Rice case, and Honorable Dipanjan Rice case, and Honorable Apex Court has said, Lord, after going through the order, we don't find any errors, so therefore we are not, and it's approving, concurring with the judgment of the Telangana laws. It's not that hard difference.
No. Still, it is not a merger with SLP.
Your Honor, kindly see the terms of the Supreme Court order, Milord.
Yes, I've seen, it's not a merger.
Merger, Milord,
No.
yes, I find almost near merger. Reason being, having heard the Royal Council appeal petitioner,
Just
2000 Supreme Court, Punjab, yes.
SCC.
Absolutely correct. Punjaba's case, entire philosophy of merger discussed, Milord.
Starting from Gojer Brothers case.
Exactly, Milord.
That was the first case of a merger
Correct.
of the Supreme Court.
Correct, correct. But Honorable Supreme Court found that no good reason to interfere with the issued order.
What can be done? If it is a petition which is taken by Telangana High Court, now other High Court has uniformly adopted it, then it that is why.
The Honorable High Court has passed recently. Supreme Court has passed recently. So we will take the instructions.
Simpliciter dismissal. This is simplicity dismissal of the matters.
Right.
And that was in case of Dipanjan, what is this? Dipanjan Roy.
Dipanjan Roy. Approving Venkataraman judge.
No, this Dipanjan Roy matter was decided on the basis of this Telangana High Court.
Correct. Well,
Now, after that, what remains?
I will verify with the instruction.
What verification? It's a verification of law by the authority.
No, I will tell you.
It's not a factual thing. What to do?
You know, associate challenge the assessment order by you. So
Honorable Telangana High Court not only quashed the notices but also consequential orders. If the foundation goes, I don't think the edifice survives. And the second challenge is, Lords, the order is passed by ITO Purulia. Yes, my business, Lords, is in Odisha. I am a registered dealer having GST.
It is here that is so far as the provision relating to a faceless assessment is mandatory in nature. And therefore, the notice under section 148 should also be issued.
Absolutely.
In a faceless manner.
Right.
And therefore, if it is not issued, then the very basis for a foundation is faulty. Then all the castle which is built thereupon will have to fall. So this is what is the spirit of this Telangana High Court judgment.
Right.
So you have not done it in a faceless manner. The notice is not done in the faceless manner.
No.
Right.
Then how? Then the order should also do. This is what the Telangana High Court says that since the notices under section 148 of the Act were not issued in a faceless manner, the entire further proceeding founded upon it and the assessment order established it, so it has to go.
Yes, sir. Right.
You want more? What more, sir?
Right.
It has to go on the basis of this, and this was reiterated by a Madhya Pradesh High Court.
Right.
Against that, the matter went to the Supreme Court, and the Supreme Court has said that I do not find that there is any error in the judgment.
Right.
So he wanted to take or innovatively derive a new doctrine, doctrine of implied affirmation.
Right.
He wanted to innovate this doctrine. That a judgment which is error, and that judgment, relied on another judgment, so it will be deemed that that reliance judgment is also a problem.
Right.
New doctrine.
Punyavad, I understand, Your Lordship is correct in saying good.
No, something new I said.
Something new, yes.
Yes. No, it can't. It has to go. And you have not issued in a festus month.
Right.
It has to go. Yes. Yes, is allowed. Go. Not big.
Your Lordship disposes this matter, 10 to 20 matter will be disposed of later on.
Let us see. Give that name so that.
Yes, Your Lordship, I will give the number.
Telangana High Court, yes, it is very clear.
Yes, yes, no. No, I am for the assessee in that case. In that case, I am for the petitioner. I mean the income tax.
Oh, that is why it's so.
I'm confused whether you have been again.
No, I'm not again. I'm not again.
No, sometimes you are standing cause.
Yes, you are switching your flag frequently. Yes.
Item 25.
May I please repeat? In item 25, petitioner is challenging the order under section 73 of the Finance Act, and similar matters are pending before your Lordship. Covered matters.
Yes, Lordship.
Yeah.
Item 26.
Lordship only paragraph 5 will also extend the date because Supreme Court has directed to release this matter after 25th August. This is 25th.
So I think they will extend the time of the month of September.
Yes,
9 September.
Item 26 minutes regarding GST RC cancellation.
Item number 27.
I challenge the given order on our universities. At plus 19 universities, because of the that has been alleged that the IPC is not, the petitioner is not eligible for the IPC because of the section 16 subsection 4 of the GST Act. The relevant party is page 19. Para number 5.1.2, page number 9. Annexure 1, page number 19 is the relevant part. Where it has been at the subpoint Roman 2 Ulysses, I find that amount of ITC avoided after the time limit prescribed under section 16.4 of CGST and OGST Act 2017 is such and such, and the same is to be recovered from the notice along with interest and penalty. But after that, Ulysses, one is notification, by notification number 22 of 2024, notification number 22 of 2024 was issued by the CBIC, the board universities. Pursuant to that, that is at, I have annexed also that also. Pursuant to that, that is annexure 4 circulars. That notification.
Yes.
Pursuant to that, one subsection 5 of section 16 was added to the Act with effect from 1/7/2017 from the date of the implementation of GST Act. So 16.5 that is there in the notification and also in the
Page 38.
page 38. Page 38, the notification number 28/10/2024, notification number 22. Pursuant to the section 16.5 was introduced. And as per section 16, subsection 5 euler seats. That is at page 43 in the notification and also in the ARC euler seats. 16.5 itself says that. May I please?
He says that though it was wrongly availed under subsection 4 of section 16, but in view of subsection 5 or the subsection 6 of section 16,
It has been regularized.
now it is available.
Yes, sir.
It is now available.
Yes, sir. And it is with effect from 1/7/2017. So pursuant to the introduction of this subsection energy, the order is.
It was given a retrospective.
Yes, sir. That is there.
Where you will get it?
Yes, page 40. Page 40.
Notification circular.
Yes, yes.
43.
Page 42.
42.
Yes, yes. First paragraph, third line. With
First July
2017. So, pursuant to this notification and the introduction of subsection 5 to the section 16 of GST Act, this order, the petitioner is now eligible for that ITC LRCs.
This is pertaining to year 2017, 18 or
18, 19 LRCs. Yes. For 3 years, 18, 17, 18, it is covered by
4 years, 4 assessment years.
Till 2021. So this period is 18 and 19, 18, 19. So now the irregularity in the order has been regularized. Irregularity pointed out by the authority has been regularized by this notification and the introduction of subsection 5 to the section 16 of the GST Act. So I have challenged that order and pursuant that order of demand order that can be in the light of 16.5 pillars, because the demand that has been raised pursuant to 16.4 of the Act says now the demand is that irregularity has been regularized, and what they have pointed out as page 19, the date of that has been reflected in let's say that
you have already filed prior to November 2021.
obliged that is also at page I have that is at page 31. The table.
Yes.
The last 4 returns, let's see. Actual filing of 3B ownership and claim of ITC. Third column, last 3 rows ownerships. Yes. December, January, February, and March. 29/6/2021. These 4, they are coming within the time limit ownerships. So my submission before ownership is that pursuant to 16.5, now the petitioner is eligible for this ITC. And my prayer for ownership that pursuant to this introduction of 16.5, this order has to go in ownership. I have also.
Is there any provision for rectification?
Yes, for that also. May
not filed.
No.
If appeal is also filed,
No.
This notification shows that there is application. The appeal is not filed.
Yes, yes.
Even if you appeal, or 16.5. But for that, for that reason, they have to file a rectification petition online.
May submit. So pursuant to that also, I have after the notification, the notification says no 148 ownerships. No, 148. Section 140. Pursuant to the notification, the petitioner, the taxpayer has to file the rectification application within 6 months of the notification of 8/10/2024. And on 10th of February, the petitioner filed the rectification application online. That was mandatory. petitioner taxpayer shall file. That was read.
Within the 6 months period.
Within, but due to technical glitches or that could not be filed online. So on that very day, he filed that rectification application offline, and that is also pending till date. Why? The notification itself says within 3 months the authority has to dispose of this. So in my prayer receipts, I have made 2 prayer receipts. First prayer to
First is interfere. Second
yes.
prayer is not interfere, then rectification has to be.
Your Lordship, in this case, the rectification should have been filed online. They have filed manually. Your Lordship, I agree.
They say because of technical glitch they could not. They have submitted a physical copy.
Yeah, Your Lordship, in this case, I will be verifying this because they have sent this rectification petition by post only.
Sir.
No.
Sir, two. Sir, two. Appended.
Yes.
Appended. Attempted. Isn't it?
Then after, Lordship, I agreed with this. They have filed a rectification petition. We have to verify, they have filed it manually. I have to verify, I'll take instruction. Within 10 days, I'll be getting the, if it is there, it will be rectified.
It has to be.
Yeah.
Now his entitlement is fructified, it is not crystallized by what's not.
Yeah, Lordship. Yeah, I talked with the officer also. He is verifying that petition regarding the manual petition has been received or not.
Already received.
And
There is endorsement. There is endorsement.
Yes, at the top of left hand side top.
Yes, sir. That is yes. Yes, sir.
Page 27.
26 is the technical. 27.
Yes. For 14 to 2025.
14 to 2025 left side.
At the left hand side two.
Again,
That's even diary number is there.
Again, let's say that was also
1026 or something.
again also it was sent through street post also. And I have annexed that,
Receipt you have?
Yes, I have 36. Yes, 36. And Honorable Gujarat High Court and Honorable Calcutta High Court has also interfered in these matters, also may pass the judgment order. If your lordships permit, I will pass the order.
This is already given.
I'll be verifying and within give 1 week time, your Lordship will be disposed of. If it will be there, it will be disposed of. Also, you have to verify.
Pass the judgments. May I submit the judgments?
Not the discussion of your petition.
Within the execution, that's a beautiful to this. It is within a particular.
But there also adjudication order which was and de novo order to be passed a direction of this.
We don't think that we are bold enough to do immediately. Rectification application has to be.
If not applied, then the direction was issued to apply. But in this case, I have applied and there is a mandate also for the officer. There was a mandate, he shall dispose of the rectification.
Yes.
Item 28.
Well, this matter relates to section 754B of TANDON.
Yes.
Well, item 29.
My Lord, in last occasion, carried my announcement to obtain the instruction regarding the appointment of the one Nagbhushan Acharya was engaged after the episode of this. My Lord, on last occasion, I failed to notice your lordship. My Lord, kindly peruse their counter affidavit. Their counter affidavit they specifically stated in para 5, page 3, para 5 and 6.
There is a counter.
My Lord, counter affidavit they submitted in the read petition, your lordship.
Right.
Oh, before the single bench.
Before the single bench. Specifically stated, I'm placing your lordship in para 5, your lordship, page 3, in reply to the affirmation made in paragraph 3C to E of the read petition, it is humbly submitted that Sri Nicholas Kasala, the appellant here, your lordship, attended, was engaged in short term.
Where from you reading?
Page number 3, your lordship, counter.
This is the counter by opposite party number 1.
Yeah, opposite party number 1. It was
Page? Paragraph?
Paragraph, page 3, paragraph 5, your lordship.
Yes.
How the separation, my lord, I'm placing your lordship, that in reply to the affirmation made in paragraph 3C to E of the read petition, it is humbly submitted that Sri Nicholas Kasala, attendant, was engaged in a short term of 44 daily wages basis from time to time as per instruction of government in H&FW department, Odisha, and his last engagement was made in this office order 3991 dated 8/5/2015. Thereafter also, and in the terms of the last engagement expired on dated 2/3/2015. My lord, it is the main point here also. And consequent, upon this involvement in criminal case, his duly wages engagement was not extended. Now there is no instruction from the government to engage employee on the daily wages basis, which is the office has rejected the claim of the petitioner by speaking order that such and such. 6 is repeated. My lord, kindly peruse their annexure, your lordship, that D1 at page 10, your lordship. With the main crux of the case, your lordship, how they favorably engage the other person was also involved with the prime accused. My lord, kindly peruse, I am placing your lordship, this is the office order that was extended from time to time, and they specifically stated that year 2/3/2005 in para 6, your lordship, I am not placed. My lord, 1 minute. Para 6 of the affidavit, your lordship. They specifically stated in the reply to the affirmation made in paragraph 4 of the writ petition, it is humbly submitted that the term of daily wages. My page, my lord. Sorry.
Let us recheck that.
There is a
page number 5.
This is another between the system and the old system of physical.
My lord.
You can immediately pass on to one from one.
Sorry,
but we have to go and then click.
My lord.
You were referring a counter affidavit, we were reading a counter affidavit.
My
You
lord.
referred D1, we went to D1, then you again went to
No,
paragraph.
for that particular
counter.
date, your lord.
How can we move fast with your pace?
Sorry, man. For the particular date, your lordship, I am placing again in the para 6 of the counter affidavit, my lord. Thereafter, I will go to the next. That in reply to the affirmation made in paragraph 4 of the writ petition, it is humbly submitted that the term of daily wages engagement of the petitioner has already been expired on 2/3/2015. 2/3/2015. At present, there is no any prevailing instruction from the government to engage any person.
Clear statement that it expires and there is at present there is no prevailing.
My lord. My lord, kindly thereafter, my lord, my humble submission, thereafter kindly peruse the page number 10, annexure D1, your lordship. Here, your lordship, the series specifically they stated, they extended the time, my lord. My name is indicated in the page number 11, serial number 36, your lordship. Wherein I was again re-engaged from 2/3/2015 to onwards, your lordship.
What?
I was again engaged.
We can't have this. From where you got it, I do not know. The record which is placed before us is saying that your extension was up to 28/2/2015.
Thereafter, the last column, there is a last column, one
No,
name of the candidate.
I keep fiscal law.
Reproduction.
Yes. Yes. He's asking about the 2015. No. It is. Petition.
Passing.
How can we gather? You are saying that extension, I do not find any extension.
38/2/2015. Thereafter, with last column, your lordship, that is not visible. It is allowed to continue.
Have not supplied to the co-op.
Sir, please show it.
That was
They
there.
have not supplied to the co-op.
Give it to him. Sir, you can find out the date, please give us. This is the document.
Yes, your lordship. They have supplied. They supplied your lordship. But your lordship, 2/3/2015 is the date, your lordship. I was re-engaged again for 1 year. My lord, kindly see my humble
From
submission.
where we'll get it?
No, my lord. My writ petition again, and accept 2 your lordship. How the suppressed the case? The affidavit, your lordship. The officer page 2000, I'm placing the second paragraph.
2016.
My lord, 27/6/2016, I'll engage. My lord,
You would wish to say that after lapse of that 28/2/2015.
yes, I was
They have again.
re-engaged again.
Re-engaged. Engaged, fresh engagement.
For 1 year again.
After that,
My
in
lord,
July 2016.
my lord,
So there was a gap.
my lord. There is no gap at all. I'm continuing there.
Where is that?
There is
My
counter.
lord is
There is counter your
seem
lordship.
to know. You see, this letter which you are showing annexure 2
My
is dated 15 July 2016.
my lord,
So from 28/2/2015
my lord.
till this letter came to exist.
Yes, your lordship.
Where is the continuity?
Continuity, my lord, it was a column, it was not visible. Not visible. They may supply your lordship. They may supply clearly. My lord. Last occasion, I also mentioned before, tried before your lordship. That person who was engaged again, has re-engaged again. He was also selected by the districts.
He was in the regular employment.
No, my lord. No, my lord. He was also
Employment like you.
that was the instruction called for by my lords. My lord, according to my instruction, your lordship, that person also engaged by the district selection committee. I was also engaged for the district selection committee. Thereafter, he was regularized. But I made some application that was not regularized.
He was also involved, but he was regularized prior to this involvement.
After 6 years, your lordship. After 6 years, after
You were not
continuing,
regularized.
that was my lord had asked for the instruction.
Both the petitioner as well as that other person with whom he is claiming parity, both were involved in the criminal case. Petitioner was initially, an order was issued putting both of them under suspension. But subsequently, petitioner was not granted extension. So it is assumed that he was disengaged because no further engagement was given to him. Now, consequent upon their acquittal in the criminal case, now the suspension period of that other person was regularized and he was reinstated into service. So far as petitioner is concerned, petitioner claiming that I should have also been reinstated into service. So he is a contractual. He was never regularized.
The other one was also a contractual.
Initially, he was given temporary appointment, but subsequently his service has been regular.
When prior to the commission of an office?
Yes. That service book, a service book has been created. His date of entry into government service is shown as 14/3/2000. That they have provided the instruction, your lordship. They have provided the instruction because last order, your lordship, may kindly see, my lord.
Not before the civil.
He was not. He is claiming parity that since he has been reinstated, why I will not be reinstated?
Produced before the single bench. Was it produced?
No, my lord. Only averments were taken that he belongs to the regular category, and so far as the petitioner belongs to temporary category, so that is why.
In the 1 year, despite a 1 year, we can 44 years in a.
The last 2 pages of that instruction is important, money. The service book entry of that person, if your lordship would see, date of entry into government service 14/3/2000. Last 2 pages,
Last week,
my lord.
14/3/2000.
14/3/2000.
It is in respect of that other person.
It is in respect of that other person. His name is Nagabhushan K. Nagabhushan Acharya.
And what is the date of his entry?
His entry, my lord.
This person.
My entry in service, your lordship, on
Only wages.
15/4/2005.
Karmora. My 17-year-old. 7/12/2006, your lordship. As per Annexure 1, I was engaged. I was appointed.
Para 3 of the counter affidavit that we have stated, it is humbly submitted Sri Nicholas Khosla, the present appellant. Attendant was engaged on the short-term 44 days basis, on the short-term daily wage basis from time to time as per the instruction.
This is the main crux of the case, your lordship. I am paying for that. I was engaged for 1 year, not for 44 days. Their counter affidavit, it is also clear, and my appointment order was also clear, your lordship, not for 44 days. I bring the kind attention of my honorable justice, honorable single judge, your lordship. That was not considered. They did wrongly written as 44 days, your lordship. They directed me to join for 1 year at the permanent of rupees 1650.
But my lord, his temporary status is not disputed. He is not disputing that as on today, he is temporary. He was temporarily given appointment.
I am continuing since last 10 years without any complaint. I have also applied for my regulation.
What is the requirement that establishment will come after 6 years of regular service?
6 years earlier, that 6 years was not there. It was only introduced in 2013. 2013 rule. That was for the first time it was introduced on completion of.
Even those who were continuing.
Yes.
For them, you have got another.
Circular.
There also it was 6 years.
Yes, a circular was issued and simultaneously.
It is a resolution.
Resolution. Government resolution.
Once you have taken that decision, and he admittedly joins in 2009. Your own document also shows that he completed more than
10 years.
More than 6 years. Because he was apprehended in the month of June 2016. So after that, since you have also recorded that since he was taken into custody for more than 48 hours, so deemed a suspension. And then you say disengaged.
Yes.
If the right to get a regular appointment or right for regularization of the service has fructified, can you take away that particular right from him?
My lord, he is not claiming regularization. He is claiming now that you have reinstated that other person to service. You reinstate me into the service.
How do he know that how he has been taken? He was not aware that he has been regularized.
But the other person The other person, that is already there on record, that he is a regular. He himself was temporary. That is not under dispute. Now he is claiming parity, that since the other person has been reinstated into service after acquittal in the criminal case, why I shall not be allowed to enter into the service? He is not claiming regularization of service.
In the same,
Yes, yes.
in the same one.
My,
They were acquitted.
they were acquitted.
What was the nature of the
The,
charges?
it is 354.
For my 354, your lordship, but 376 against him. There is an
The other-
interception. The main judge who was engaged, they were reinstated, your lordship. 376. For that, I am present there. When the office attending the doctor's, your lordship, falsely the lady was given the name. He was also present.
During trial, that lady turned hostile.
So whatever. Annex 3.
And like,
Sir, that's have you seen the judgment?
yes, madam.
Then you can't say the allegation of moral turpitude. At least against him there was nothing. He was not an active participants of commission of an offense. Only allegation is that he aided and abetted, nothing more than that. He did there.
354.
And the very, I would say, astonishing part of the entire episode is that the complainant who lost the FIR did not appear before the court to depose, did not dare to face the cross-examination.
I'm sorry.
Well,
Grave, despite grave
and
allegations,
just the other person whom you have regularized, whom you have reinstated.
There was a grave allegation against him.
yes, but
But
that
I-
PW1, the prosecution witness, that is Subhadra Sahu, the lady who alleged that she did not whisper a single word implicating
I'm
the.
telling you, she did not depose I's case.
Yes.
That is what I'm saying.
Yes,
She
yes.
did not come forward to depose
Yes.
against them.
Yes. So that is why
It's an
the,
acquittal under, it should be an acquittal under section 232. But for some other reason, it is done in the 235.
but they have observed that she was declared hostile by the prosecution. That has been declared by.
True, you could not come out.
Yes. So what?
So what?
Your
And
lordship may
the
kindly.
serious allegation against one, reinstated, and a minor allegation against the other.
In a similar nature of issue, my lord, Commissioner of Police New Delhi versus Meher Singh. This is a reported judgment, 2013, 7 SCC 685. So Lordship, I'm citing.
That is in a disciplined organization like a CRPF, the police, the army, where the misconduct is more stringent, strict than in the civil service.
But only that para 24, where the
I'm just reminding you of a distinction.
Yes.
For that there are judgments.
Yes, my lord, there are judgments. Lordship, para 24, last 5 lines, your Lordship, quite often, if my lord should have got it, quite often, criminal cases end in acquittal because witness turn hostile. Such acquittals are not acquittals on merit. An acquittal based on benefit of.
This has been diluted to some extent. This has been in GM time. It was the honorable acquittal and the acquittal was made distinction. Recently, it has been said that what is the distinction between an honorable acquittal and the acquittal? In a recent judgment of 2024.
Yes, 2023, man. 2023.
Judgment is also there.
2023, that is Imtiaz Ahmed Mullah versus.
It says that there is no distinction.
There is no distinction.
The Supreme Court has deprecated it.
Yes, but in case of Avtar Singh, if your lordship would kindly see, last occasion also I cited that they have summarized, referring to various judgments. Lordship may kindly see Avtar Singh. If I take your lordship to para. Well, para 38. So lordship may kindly see. That is last page, page 507. We have noticed various decisions and tried to explain and reconcile them as far as possible. In view of the aforesaid discussion, we summarize our conclusion thus. Then your lordship may straight away come to 38.5. In case where the employee has made declaration truthfully of his concluded criminal case, the employer still has a right to consider antecedents and cannot be compelled to appoint the candidate.
Oh, this is what is the case?
Yes.
That was the case when at the time of offering his candidature,
yes,
there is a declaration which every candidate has to make. There was a false declaration which was given.
Yes.
Then all the line of judgments are that if it is found that there was a false declaration which is given, then in that event there is no question of following the principle of national justice or something. He has to go out. Second line is this line of judgment. This says is that suppose if he has disclosed, yes, there was a criminal case. Yet, it does not mean that since he has already disclosed and the acquittal has been made, that the employer cannot go into the antecedents. He may choose whether to employ or not to employ. How it affects in the instant case?
Instant case because 38.5, that specific paragraph relates to the employee. If your lordship may kindly.
Sir, probably it's my incompetence that I cannot calculate what is playing in my mind. There is a gulf of difference between a case where the employment is secured by giving a false antecedents or disclosing an antecedent of the criminal case, having instituted and the acquittal has come, to a case where he is already there in an employment,
yes,
and then on the basis of the FIR he was put behind the bar and thereafter he emerged successful in the form of an acquittal and claims the continuance of service. How can you make both the judgments on one common pool?
This judgment specifically
He was already in employment, sir.
Well,
Then these are the judgments when you say, then I have to go to M.S.RAMAN and Curry principles followed subsequently.
well, Paul Anthony, My lord, voluntary, that
That
judgment.
was a case where the acquittal is there, and if it is on the same set of facts, it is on the same witnesses, it's the same documentary evidence, then the departmental proceeding has to go once the acquittal has come from the criminal court. Here is a case, he says that both of us, against me, it was not that grave. I was not a direct perpetrator of an offense. I may be a facilitator of an offense. There is another gentleman against whom the lady has directly made up the finger that he is a person who has committed an offense. Now he is also acquitted, and the other person is also acquitted. Other person against whom such a grave charge was made, he is reappointed.
He's not reappointed. He is reinstated because his suspension was revoked.
He is impressed by the employer. Come back. You have been acquitted. We respect your the position. Come back.
But that
for him, you say no. There was a serious allegation against him.
But that person,
I will not engage him.
But the other person was never terminated. He was only put under.
He was also suspended. That letter,
suspended, but subsequently
engagement letter. If you come, the second paragraph you read.
Yes, your lord.
Read second paragraph.
And whereas the said Nicholas Khosla, daily wages sweeper of CSC, Narayana Patnaik, deemed to have been suspended with effect from.
He was under suspension. What are you talking about?
But he was under suspension. Your lordship may kindly see the provision in vogue. That is that provision.
No.
That is the Odisha. But that is fault on our part. But he has been disengaged.
So in
The other person was put under suspension and reinstated. His
Sir,
suspension was
put him under suspension.
but subsequently he has been disengaged. Your lordship may kindly appreciate.
You are not getting. I think our wavelength is not matching. What I'm saying, when you say that he was under suspension, let me say that he was not under suspension. I said wrong. You put him also under suspension. But after the criminal case is over and both of them were acquitted, you revoke the suspension of the other person, reinstated him. In his case, you say that he was under suspension, but I do not want to re-engage him or I disengage him from the service. This action is tested on the ground of parity. A person has acquired a right of regularization much prior to the commission of an offense. And if the employer has not provided or respected that right, whether an employee can be put prejudice or a suffer.
He has never claimed regularization. Regularization is not an issue at all.
Then saying it is, what is the rule? It says that the employee will claim regularization. Unless he claims regularization, authority will not regularize. What the rule says? Rule says that after completing 6 years of continuous service into, he is entitled to be regularized into the service. This entitlement is an important facet.
That is subject to certain conditions prescribed in that particular resolution, Mali.
What are those conditions?
Yes.
What are those conditions?
Those conditions in
that the employee has to make an application seeking regularization?
No, Mali.
No.
That is not the condition, Mali. The condition was that if the appointment has been made against a post which has been surrendered and contractual appointments have been made against the posts, then in that case he can claim regularization. Then that regularization is subject to the provisions provided under the Odisha vacancies of reservation rules.
That you have brought it in 2014 as appended. But in 2013, there was no condition.
13 has been clarified.
By 13, he completed 6
But
years.
13 was
By
clarified.
13, he completed 6 years. In 2014, you added certain conditions as if it is ingrained in 2013.
No, but 14, the conditions were not added, but only the conditions were explained, which were already there in 2013.
Explained.
I can produce that resolution if my lord should ask me.
While many it's that ORB Act will not come to your rescue, rather it is beneficial to them because the employer has not taken care of at the time of engagement. So it is for the fault of the employer. We should
Regularization,
that is confirmed in the
temporary employee, he has not claimed regularization.
The difficulty is, my view, I have already explained after Jago and all everything.
But that is not dispute. That is not at all dispute. I cannot never dispute that my lord's judgment on Jago and that Arun Kumar Nath and Sripal. I cannot dispute that.
Mr. Das, there might both aspects that angle is at the lowest strata of the lowest strata, you can say, of the group D. And he
is only claiming parity for his reinstatement. I leave it to my lords, but my lords can what I can sweep because they have not enough.
I think you should impress upon the authority considering this.
That I'll try my lord if the lordship. And in some time then.
Yes, sir. This session case, yes, there was something wrong.
And have you seen that?
At least he was not there. The other was.
The other was charged with 376, 354. He was charged with 354 only.
First line.
It is available. It is there.
Paragraph of the judgment of
Prosecution miserably failed.
Well, so far as
Yes. Yes. That I cannot, because I cannot do.
His role was negligible. That is what swayed our minds,
Yes,
to be very frank. Had it been the just reverse, that he has been taken back, that gentleman is not, we could have appreciated it because there was a very serious allegation and a direct allegation against him. He is a fringe issue.
And take instruction from the.
May I use the term small trial?
Then I
Understood. Having lot of.
matter. I know.
So does when I was in single bench also certain matters. I think in other departments or this department, in such type of matters, you have re-engaged. You have taken steps to re-engage.
Temporary employee, I'll take instruction from the operator.
It's always in the temporary only. He will again come forward.
After he is reinstated. I'll take instruction. In some time,
means in a positive way.
But this paragraph 10, that
yes.
And the line of
We are really seeing this Monday week. Not this Monday week, but
Monday
week.
Kindness. Yes, his livelihood.
But
after serving for many years.
You are a model employer. Only thing convey.
I was only doing my duty.
No, means not saying.
The authority.
Yes.
Right. Item number 31. Item number 31.
There is Mr. Maheshwar Mohanty.
Difficulty?
Item 32.
Term 32 on behalf of Vrindavan Rao, kindly taken up 2 weeks after Vrindavan. Last 2 years, lots of the answer to the mental.
Item 33.
Lordship, item 33, Lordship. Requisite has filed, Lordship, in favor of opposite party number 2 and opposite number 5.
You have not filed.
Lordship, I have.
When you filed today?
Tomorrow, yesterday.
Yesterday, this matter was on hold.
Kindly be verified.
You are the time you accepted. Make the service indicates.
Item number 34.
Yes. On daily only much of the notice was issued, so I've only received the IA copy.
Okay, you wanted to hear you on delay.
I have no objection.
Then we conclude.
Weeks. Yes, sir.
For admission or actually admission. And 60 capital A. So substantial question of law. What is?
Item 36.
Serve a copy of the written appeal as well. No, she has no right of audience before admission. But it's still served.
36.
Morning counsel for the opposite respondent was supposed to file an objection. Because the directions.
Nobody is appearing.
On the last occasion, he had entered appearance.
What to do? Will you proceed ex parte? Who was the advocate? Sasi Bhushan Jagannath.
Man.
You know him?
I know him.
Can you contact and call him?
Not sure, like, flip it to the afternoon.
How many days did you?
141 days. 130. 130.
Item 37.
Donation.
Is an additional the last occasion.
No. Have you served the copy?
Yes.
How many days delay?
140. 147. Notice. The last occasion we see the page 12 of
What will say? Donation?
147. After your lordship goes through this order, this particular letter or correspondence, then your lordship will be dismiss this application.
As the annex?
Yes, annex in this.
An
additional affidavit.
The condonation application.
Like 2130, that's today's affidavit, additional affidavit. Yes, phase 12 kind of a class. Flag X. Last, out of 147 days, they are initially in a mood to comply the order of this.
No, where is?
Last flag X.
Phase 12.
Phase 12. Last line, you also can last graph. In view of the above, the possibility of winning this appeal is big. We can take a chance
Acha.
We can take
You
it.
have no possibility of winning in appeal is bleak.
Yes. We can take a chance by filing an appeal against the judgment and order that it so and so. Then there is an interference.
What is this? It's like a toss of a coin. Let us see.
This is a fact on record, so I brought it.
I'm obliged really because he has disclosed everything.
I could not have kept it because we have to explain the deal.
Communication?
Yes,
Internal communication.
yes, this is internal communication.
The officer has opined.
I had opined, my lord, last time my IA was sketchy as far as the explanation for the delay is concerned.
So that's why you did not explain sufficiently.
No.
In the original.
No, I had explained it. I had explained, but all the material facts have been brought on record. Lord, I leave it, my lords, but my lord.
Taking chance. He's not serious.
Well, actually, on merit, may not. I know that this is not the forum till I have crossed this hurdle. But the
on merit also, yes,
he
must admit that
the order emanates from a direction because there was a typographical error
in my application. The khata number instead of 98, it was written as 93.
So there was
that is the only mistake. As the successful person, my application was accepted, but at the time of scrutiny, my application was refused on the ground that there is a typographical error. Instead of 93, I have written it 90.
He was rejected in the process of selection by the impugned order.
Instead of 93,
98.
98, I had written it 90. Only one. Yes, one.
That was introduced. Yes. Was it a typed one or it's a handwritten?
No, online application.
Online.
Oh.
There is a mistake, and there is no such
human.
Human.
And the written code has accepted
Yes.
that.
So that is why my lord is.
I think better to dismiss on section 5 if the authorities
Because
committed a
yes,
delay.
Be fair, there was an issue.
Committed a delay, so
they
that is
just
not on merit on section 5.
not that the order should be an a precedent in other cases. In the particular facts of the case, so no reason to object.
We are discussing section 5.
As my lord pleases.
Yes.
Item 38.
Item number 38, my lords. Counter have
Lord, I have
been
a-
prepared, my lords.
IA.
Counter affidavit has been prepared, my lords. 1 day time may be granted.
I have one IA. Well, Lordship kindly consider my IA. The counter they will file and file present that matter will be your Lordship will hear it. If they actually the IA is that my dispatch of the mines ore, my lord, I have not been able to. They have stopped dispatch of my ore after mining because of the wrong demand. That is the reason. The Lordship kindly see this first 3 interpretations there. First 2 interpretations, I have deposited the demand, though I have challenged the demand, but I have deposited on protest. Third one, my lord, I may permitted to deposit the amount, whatever they have demanded on protest, subject to final outcome of the case, my lord, and I may be allowed to dispatch. That is the demand. That is the only limited I have filed.
So where is the difficulty?
No, my lords. If they are ready to pay the entire amount, then there is no.
No, says I am depositing the demand, whatever you have made.
Yes, my lord.
Without prejudice to their rights and conditions. And if they deposit, you are concerned with the liability. Now they have deposited, then you permit them to.
Yes, my lord.
Because
Only simple that is
they are also losing, the government is also losing revenue.
But where is that application?
My lord, IA is the flag B. Flag B, my lord. 14316. Because the other 2 cases have valid 14316. The last repeat.
In other cases, you have been.
I have deposited on protest.
And you are permitted to.
No,
I was permitted.
I was permitted, but subsequently on this ground, this third year, they have stopped it from February. From February, they have stopped it. Demand is also when I have paid 73 annexed of 4. Oh, sorry, the writ petition pays 73 annexed of 4. It is relating to same mine, relating to a different period, my lord, but this is my lord, annex of 4 pays 73 of the writ petition.
23 crores.
23 crores. 23 crores, 62 lakh, that 23.
So there is no difference.
No, entire amount in my looks, there's no difficulty.
These are for different period.
substantial dues are pending, my
They
lord.
have already deposited, I have said.
No, my lord, other
Already
matters.
deposited. First
my
and
lord,
second one you have already deposited.
My lords, in
Okay.
writ
We have
petition
also
number
filed the proof.
40308.
I have already said that they claim that.
Yes, we have already filed the proofs also.
I have already called.
My lords, only one submission, my lords. In writ petition number 40308, I have upon instruction saying, my lords, approximately 243 crores dues are pending, my lords.
No, it is not there in the writ petition. Let them say.
My lords, for
Not there in the writ petition. 1 crore, the writ petition is there.
no, my lords, they have given
The
the
figure.
23 crore.
no, my lords, in other matters, my lords, subject to
Whatever they have deposited.
subject to clear other dues not being pending, my lords, because the portal will automatically get blocked if other dues.
As we appear from the stand of the.
So this is a case, my lord,
The nature of the claims.
My lords, before my lord, this a request for a short time, my lord, because this matter is marked with Debashish Tripathi, he's under some difficulty, not in Debashish Tripathi, AGA, my lords.
my humble, my lord, only my lord, request your lordships that there is a contract was executed. Post contract pursuant to another case, the work was stopped. This honorable court by the interim order dated 13 May
How
2025.
much time you
But
require?
tomorrow, my lords, if these matters can come tomorrow, my lords.
No, tomorrow.
Day
my
after
lord,
tomorrow?
yes, lordship, day after.
Day after.
Item 41.
Right, please, your lordship. My lord, item 41, your lordship, I am before your lordship on a very small issue. Now, your lordship may consider whether for a human error, a person can be punished, wherein there is no fault of any party which has occasioned loss to nobody, and absolutely thereby nobody is harmed. It's a human error, and by mistake something has happened. Your lordship may kindly see the petitioner has applied, your lordship, and participated in the tender.
What is this? What is this?
The petitioner has applied for a tender, your lordship, participating in the tender floated by Odisha Police for supply of testing kits. The petitioner
What
has
kits?
Item 41.
Testing kits.
Testing kits, my lord.
Yes.
Those kits were required to collect sample, blood sample from the spot, earth from the spot, and other areas which will help them in investigation. Those testing kits I was supplying to them. Those they were using for forensic use, my lord. Forensic purpose they used, and they floated a tender. I participated. I was a L1 bidder, and I supplied, your lordship. Now, from 1/9/2023 to 16/10/2023, my lord, I am submitting a date chart now, which will make the entire matter clear. It's a very small issue, my lord. Only 5 minutes time I'll take. I'm submitting the date chart, your lordship, and I'll place from the date chart.
What?
My lord.
My lord, 40, 41, 42.
No, your lordship, I pray, my lord. My learned sister may consider. I am placing. If your lordship will consider to defer
But
it.
she is not an advocate on record, and she says that somebody else is there and he is unable today. So she has prayed for the matter to be taken up day after tomorrow.
My lord, my prayer, my lord, your lordship may consider this is a debarment order passed on 5.
So he is opposing your prayer, madam. What can be done? Then we'll have to proceed ex parte.
That's,
He is opposing your prayer for adjournment.
Your Lordship may consider, my learned sister may consider. I am placing, if my learned sister feels difficulty in my, because everything is admitted, my Lord. I have committed a mistake.
Mr. Mishra,
My Lord.
only 48 hours she seeks.
May I, my Lord, may I make a small prayer?
Would you not accommodate?
Yes, my Lord. Yes, my Lord. I bow down. My Lord, may I make a small prayer? High paid 2024, they have debarred me for 2 years. Now it is coming almost 1 year, Your Lordship department. The difficulty is that I am unable to participate in any tender across the globe because of this
So day after tomorrow, come back. She is in genuine difficulty. What you will do?
My Lord. May I make a small prayer, my Lord? Day after tomorrow at 2 p.m. Day after tomorrow at 2 p.m., my Lord, may kindly take up this matter. Only 5 minutes.
At 4:30 p.m.
Item 42.
Yes. Come, we'll take up. Don't worry. Just remind us.
My Lord.
42.
Same prayer she's renewing.
Well, yep.
Convince him. She's in difficulty.
Well,
She wanted a day after tomorrow. Yes.
Item 43.
Same prayer.
Your Lordship, I challenge the constitutional validity of particular provision. Perhaps
She is in confusion. Please.
Your Lordship, original to appear, Lordship, there is error.
She is grappling with the heap of the briefs. She is unable to find out in which matter she is there, in which matter she is not.
Once it happened to me also, standing there, piled up cases.
if we know that learned AG has to appear in this matter, my lords. Challenge to section 26(2) of the Gram Panchayat that the wires of section 26(2) has been challenged in this matter, my lords. 26(2) of the Gram Panchayat. 26.
No, she says 26(2).
26, let's we see saying 26(2).
26, my lords. 26 of the act. The wires of that section is under challenge, my lords.
What?
That's the my lords. That's the candidate. With assist your lordship, my lords, in this matter.
We have fixed some matter for him in the next week, I believe. When
Some matters are fixed on 31st as well as.
for him. So keep it on 31st.
Lordship.
Yes.
Along with other matters, Lordship.
Item 44.
Only this one. Yes.
Only matter. Lordship, let's come fresh admission for that.
No, we'll dispose of. Let us first dispose of one. If we club together, there will be a
I'm saying
large number of advocates and everybody will argue. So it's better to choose one, dispose of, on a proposition of law that will follow.
34.
I have prayed for release of admitted dues, Lordship. In this,
What dues?
release of admitted dues, Lordship.
Yes. How much? Where is an admission? Where is an admission?
Lordship, Annexure 3, Lordship, Annexure 3, Lordship. Annexure 2 is the Lordship, the work completion report, Lordship, kindly go to the Annexure 2 first, it's page 15. Annexure 2, page 15, Lordship.
Yes.
So work completion in respect of the work, Lordship, the work is described in Annexure 1 as page 14, Lordship.
Then 16.
Where is the authority? Next, Annexure 3, page 16, Lordship. The authority in the first paragraph, Lordship. Inviting a reference to the subject cited above, it is to include that the allotment for an amount of rupees circumstances. The 50 may kindly be placed in favor of the division for the financial 23-24.
So that
My serial number is, Lordship, serial number 2 from the bottom, Lordship. It's 4,87,930. The work amount.
Yes, serial number
2 from the bottom. Serial number
4,86,000 work completed.
Work completed.
Yes.
4,87,000.
What are you doing?
Thereafter, Lordship, the annexure 4 also.
They are demanding that fund.
The fund also available before the authority, releasing authority. OP number 5 is the releasing authority. OP number 4 is the fund allotted authority. This
What
is
are
OP number
A
4.
person has to approach. Yeah. Since when your money is not paid?
My lord, the 28/3/24. That is the fund was
You are
available,
not
but they did not release.
You are not given the brief.
In the next day, they refunded.
You are not given a brief.
That's the matters are marked to.
Yes.
So the
No,
party is
probably, but she is only doing the substitution. She is
Then
praying for.
who is engaged?
No, he has not come. That's what.
Who-
At the last,
who?
at the last hour, she is.
Somewhere because of some personal difficulty, my lords.
This matter can be disposed of on one. Put it tomorrow, it can be disposed of. There's nothing which you can, because everything is admitted by you.
Then go through it, my lords.
Everything is admitted by you, you'll have to, whatever, you can't unreasonably withhold the money, genuine money.
And
He has
today,
come.
if you can speak to person who can release the funds.
Tomorrow is to
better.
be mentioned. Keep it as tomorrow is to be mentioned. Tomorrow come as to be mentioned.
Item 45.
May I please your office?
All the rest is same.
45, my lord, 45, 46, my lord.
All the matters.
My lord, 47, I have the brief, my lord.
That in item number 45, with my lord's kind permission, not only the work order has been issued, but also the services of the school is at jeopardy. Because the tender was related to providing manpower to the Odisha Adarsh Vidyalaya schools, my lord. For 7 months, the counter affidavit, my lord, the state has admitted all the.
What others Vidyalaya school? Somebody is coming that my daughter is not admitted in class 6 in others Vidyalaya school. You are coming that others Vidyalaya school is not provided all the facilities.
It is not about facilities, my lord. The tender was invited, my lord, to provide manpower service providers 27 numbers of in Odisha Adarsh Vidyalaya in 9 schools, my lord. Thereafter, my lord, at the stage of financial bid, the contenders, they quoted the same price bid. Thereafter, lottery was conducted. I became successful. Thereafter, one of the contender, my lord, he made an allegation against me that way back in 2016 and 17, I was blacklisted, my lord. Therefore, my lord, work order has not been issued. Your lordship may kindly see the counter affidavit.
Blacklisted for how many days?
I was never blacklisted, my lord. It was a vague allegation, not a scrap of paper to back it up. Thereafter, my lord, your lordship may kindly see in the counter affidavit.
Then what happened? What they are doing?
They have stated in the counter affidavit that it is decided to issue work order in favor of L1, that is Royal Security Service petitioner.
You are.
My lord, but
so they have decided till date they have not.
Not, my lord.
Intervention. Who are you?
L2.
L2, then why? You are challenged have you challenged that particular order?
That order, Lordship,
Have you challenged by filing a writ petition? Madam, I am asking you. When the tender was finalized and he was declared, so what is your right? What is your right to intervene? His grievance is that despite having been declared L1, the work order is not issued. If you have a grievance that he could not be issued in work order, they could have come. Challenge that he cannot be an L1, he should be scrapped. The order has to be issued in my favor.
He allowed me, I got RTA documents.
What?
That's it.
That cannot be. The authorities have, you go before the authority and file everything. What we will do here?
The case is sub judice.
No, they have filed a counter affidavit and they have disclosed that they are going to issue a work order. If you have any grievance, you have to go and approach the authority.
But paragraph 3, your lordship may kindly see of the counter affidavit. Internal page 2, running page 34.
Yes, correct. that is there, go before the authority. No. Where is there is an admission.
But however, in paragraph 4, we have mentioned an allegation was received from one Lakeshwar agency on the same day by letter dated where it is alleged that MS Royal Security Agency was blacklisting agency in District Education Officer Balangir.
So there is nothing which is coming forward. There is a bold allegation. Nothing came forward before you. How can you without, even if, let us see, if there was a blacklisting, if it is for a particular period and the period has expired, does it continue eternally for his entire life? Does it?
As per the OPWT code, my lord, even
Whatever, if it is for a particular period, then after that period is over, that does not mean that he suffered a civil death for all time to come.
and for 7 months I have been denied work order, my lord, for 7 months.
Whatever.
Case is pending.
So what?
The condition is there.
There's nothing. Criminal case is pending. Criminal case may be of a 498 nature.
No.
Maybe a 125 CRPC application is pending. Criminal case is pending.
Allow him.
Nothing. Nothing.
At document, lordship, kindly see the.
No. You have no right of audience. You have no right of audience.
And condition, then the terms and condition.
You move to the authority. Let the authority do it.
Maybe directed to the. Condition number 10, lordship, kindly. Read petition page number 14.
Last order there was.
Yes, where is the document? Where are the queries? It's against an ESI and the EPF. If they have deposited what more? This is a criminal case against them. Moral turpitude. And no information has been sought for. No information has come from your side. Your application is under process. Blacklisting, from where you got that he has been blacklisted? From where you got that he has been blacklisted?
That's it, the criminal case is pending.
Sorry, that was only in respect of that he has not complied the statutory provision of EPF deposit of the employer's contribution under the EPF.
Till today not deposited.
Sorry, that they will, he has a right to appeal. He has a right to appeal.
Maybe directed to authority.
Sorry, nothing more than that. Look, this is an application for intervention at the behest of
I
Very
said they have
difficult.
taken time to
Let
take
her
the
come.
inspection.
You are ready in the matter? Come tomorrow. I can, a day after tomorrow. Come day after tomorrow. Yes. Day after tomorrow.
46,
Apply.
Come ready, sir.
item 46.
Same problem.
What?
Same problem. She's not marked.
The difficulty is because she's marked with some matters and thereafter.
I understand her difficulty.
Yes, here's the.
They should be for this side. She's our poor girl.
We are talking to each other, in fact. Others should have been here.
And that is.
No, she says that there was one lawyer who was here, he was present. But he personally, because of some emergent situation, he left the court. So.
That is the problem sitting this side.
So next week, Monday, that is
The counter is to filed.
Yes, but the affidavit has to be filed in 46 minutes and time.
This is last study was a very thing to.
You prepare it and file it in the next week. Yes. 47, the same problem.
Interim order to continue.
Interim order. By affidavit, counter affidavit. Interim order to continue.
Yes. 47.
Item 47, I appear for the petitioner. She's not. She's not. This is a public interest litigation by some villagers. Where my lords, at the outset, I must apologize. I had not brought to the court's notice an amendment to the EIA notification. Where my lords, there was a.
What is this EIA?
This is an environment impact assessment notification. When there is a rescheduling of a public hearing, the time period that is to be given is 15 days and not 30 days. So profusely apologize because that was a subsequent amendment and complete oversight on my part that I could not bring it to my lord's notice.
Correct.
There are two other points, my lords. Therefore, my lords, on that count, my lords, I concede, my lords. There are two other points. The two other points being that the villagers have been physically restrained from participating in the public hearing, which was held on 18th of January 2025.
You are representing all the villagers.
My lords,
only four.
There are four petitioners here, but my lords, this is the nature of a public interest application.
So you are espousing the cause of all.
All. So, my lords,
Busybody.
As the may I place my case?
I was thinking in a different line, whether it is a class action or like a representative character. Order 1, Rule 8, I was thinking about it, whether the leave has to be obtained or not. Anyhow, public interest litigation, yes.
So, my lords, as per the environment impact assessment notification, para 1 of that notification says that the public hearing which is to be convened, they have to ensure maximum participation. Now, my lords, these are about 13 odd villages.
Now, who is the opposite party number 5? You.
I'm 7.
But there is a counter affidavit has to be filed.
Not all the counters are filed. Give me just 5 minutes.
All counters have been filed.
Everything has been filed.
5, 6, and 7 I find. And
I
what
have,
about?
my lords, filed my rejoinder as well.
No, let me tell you what it is. Give me just 2 minutes. Lords, I am a group of the SR Minimate Limited. Of the SR group.
Okay.
And making a huge investment in the state. But what I'm doing is, I'm setting up a 14.3 million ton iron ore beneficiation plant at Kyonja. So what is the beneficiation plant? Upgrade the low grade ores. I take them to Paradip, but there I have got a 14 MTA pellet plant. 14 MTA pellet plant. But what is pellet? This low grade ore is made into high grade, sent to Paradip, and they are manufactured pellets. Now my pellet plant already has a EC at Paradip. Now this plant, my lords, both the plants are interlinked, and I am going to generate huge employment in this field.
Are you still under the control of DSR or you have gone?
No, we are out of all that now. We are out of all that. I quite forgot.
Arsenal.
Arsenal is all. So this is all virgin now.
Because I had an occasion there to deal one case, that's why I'm
Lordship is quite right. That's quite right.
I delivered a judgment there.
And this is, my lord, SR2, if your lordship may say so. And my lord, the foreign exchange earnings of the state will be in excess of that ArcelorMittal ISAR takeover.
It was a case which came before me. I was taking up on that's a commercial appellate division.
Yes, Lord.
There was a company called Odisha Slurry.
Slurry pipe, that was the slurry pipe.
Slurry pipe. So when this arrangements of the taking over, because the SR has gone before the NCLT.
The slurry pipe was again from Keonjhar to Paradip.
So they used to just flow with the water. There was a pipeline which was set up, or so that from the mines straight away to the particular place where they make the manufacturing process. So there was a management agreement which was there for user of that particular, that dispute that came up. So that's why I know this fact, because I had an occasion to
Your lordship is right.
deliver a judgment.
Yes. I bow down. So what happens is, for the purposes of AC minutes, one of the conditions that are required to be fulfilled, there has to be a public hearing. And a notice is issued for public hearing. And what it says is that you can appear in person or you can make a representation. So both boards are available. Now, my learned friend, the petitioners, they come before your lordships and challenge the public hearing on two grounds. The first ground,
ground is the duration.
They say
So he has really abandoned it because fairly said.
Correct.
He's not really claiming.
So now the public hearing was attended by 217 persons. Out of that, 85 persons gave written representations. Nothing stopped them from giving written representation. I would further go to say that they can still make a representation to cut short the whole litigation, because these projects are now languishing. The projects have to go ahead. A lot of financial commitments are to be made. And we're not dealing with a similar matter. Your lordship sitting in division bench, your lordship predecessor. The lordships are passed an order saying that you give your representations. These four gentlemen, their whole case is what? We could not attend. Let them give their representations to the additional standing council. That will be sent to the state pollution control. What they will deal with.
So that they appeared earlier also.
No, this is another case.
Another.
Your lordship may see there is an order of 11th of lordship may see there is an order of 7th of April. My lord have it. My lord have it. Order number 7.
No, this order number
7.
No, there is no. That I have already read.
Yes. So what here your lordship said, if you have been prevented, that is the case. My case is, my lord, PI is not maintainable. I don't want to go into all that. So now 15 days period, that point is gone. What we are left with is, these four people say we could not attend. Now you file a representation, they will be considered. Because the notice itself said that you can appear. But I just showed the notice, that is annexure.
How many persons are there? Which village he is really got to represent?
The villages in all what he is aware. He is 7 villages. And if your lordship sees page 21.
And how much population of the
about 20,000 is what he says. Look, your lordship may see page 21. Lord, what is his grievance? His grievance is, if your lordship will go to before going to 21, kindly see page 7 of the report. His grievance is there be a lot of effluents coming out. Para 7, page 7. My lord just has page 7, para 7. My lord the Chief Justice added that as per the environmental assessment report, where the project published in so and so, the water requirement of 730 cl per hour would be the source by the. We are not concerned with that. The report further states that the process effluent would consist of wastewater dewatering of residual fines consisting mainly of suspended and dissolved solids. Apart from them, there will be generation of sanitary watershed. Now kindly see page 21, annexure 1. This is the report of the public hearing. Your lordships have page 21, madam. My lords have it, annexure 1.
Yes.
Kindly see serial number 4 minutes. Kindly see serial number 3 first. Sri Narayana Rao, President Parivesa Suraksha Samiti. My lords have it. What he does, Mr. Rao said that they have placed their opinions in the form of written representations before the administration.
Who is this Narayan Raut?
He is one of the, he's the local area person and he's.
This village villas is not, it's in Yoda.
Now kindly see Guru Charan Barik Tikkarpada. Your lordships have it. Serial number 5.
Yes. There are 2 Tikkarpada.
Yes.
One is Dinesh Behra.
Yes. I'm reading Guru.
Oh, he is overwhelmed with the project.
No, what he says is Guru Charan.
Dinesh is.
Yes, because they're all wanting employment. They are all wanting the plant to come. Kindly see 5. See, Guru Charan welcomed the project. My lordships have minutes. 5. He worried about the management of wastewater. This is what was his complaint in page 7, para 7. He queried about the wastewater to be generated from the plant during operation, as it is likely to affect the Nala that passes through the plant side. So therefore, environment is addressed. In addition, if my learned friend so desires, 4 of them can make a representation by way of an affidavit. Give it to my learned friend.
He is representing this Tikkarpada.
No, he represents 4 persons. Kindly see the cost.
No. Which village?
Kindly see page 4.
We have not disclosed which village.
There are 3 categories and 1 Dhakita. Kadagoda. Your lordship is right. Kadagoda and Dhakita.
Dhakita is also.
Yes.
Kadagoda and Dhakita.
Correct. So if they want, they can give representation which will be considered. Because they should have averred before your lordship. Why didn't they make a representation? Kindly see the notice note. Just 1 second and I'll be done. If your lordship sees counter affidavit, of respondent number 7, page 22. It is B by 7. Annexure B by 7.
Black D.
I'm so sorry. It's grateful. May I read it? My Lord the Chief Justice has. It is dated 2nd January 2025. It is brought to the notice of all concerned that the State Pollution Control Board has issued an advertisement in the newspaper.
So is there the new Sunday Express as Premier?
Yeah.
Prameya.
Yes, ma'am.
Was published on that.
And what it says is.
And there is invited
application
from Tikkarpada.
Yes, any person who is likely to be affected by the grant of VC. So who are the persons who can come? Any person who is likely to be affected, owns his control over the project, association of persons, any local authority. Now kindly see, persons as above who decide, my lords have that paragraph.
Who desire to submit their views and comments and objections.
Objections, etc.
Within 15 days from the date of the publication.
Addressing the same to the member. So they can.
Correct.
Whereas I have 2 submissions. In this petition, my lords, I have not averred anything with regard to the environmental impacts. My petition, my lords, is limited to the petitioners not being allowed, the petitioners and many of the others.
So make a representation. Now we are allowing you to make a representation. Go there, make a representation.
My only submission is.
But you can't forestall in this fashion. Let the environmental authorities take a decision.
Yes. My only submission is within the framework of the.
The environmental authorities, if they transgress their barriers, is statutory. You have a right to take action against them.
I may only consider that the views that will be given by the petitioners will be put up before the expert appraisal committee.
Sir, you can't control that how the authorities should function. If there is a law, there is a rules that how it has to be done, they will take care of. If they do not follow the statutory norms, then in that event, their action is to be tested. It will be tested. But you can't dictate that you do this. You will not cross the right leg over your left leg. You will not do this. How can you dictate the authority?
As per the framework, statutory framework. That is my only submission.
They have to act it. They have to act within the proceedings of law.
Your Lordship may say that statutory procedure will follow.
Oh, that is what is there. The
May I appeal for pollution control board? After completion of the public hearing,
Sir, he has referred now there are certain persons. There are certain persons who could not approach you within the time.
Yes, correct.
So now we are saying that if they have any grievance, they can make a representation to you take a decision in accordance with law. No difficulty.
I would go one step further. Let them make representation to her. Tomorrow they will say he didn't take any action. So my learned sister will send it to the department.
Now you are putting him as the post office.
No, as per
She will act as a post office.
Sorry, I take it.
As per the EIA notification, it is the duty of the board to send it to the minister. All representatives also send it. So board should.
So they will make a representation to you.
Yes.
Not the central government is a OP number one, we don't have a rule. Yes, ma'am.
What?
So OP number one, if it is a party, we don't have a rule. The state will act upon this.
Oh, your name would be recorded for good purposes. Don't worry.
But what my land friend is saying that it should be dealt with by the Union of India, we don't have a rule. This.
Oh, whatever. Yes.